per case of the petitioner. His other cases are going to be listed on 21st of March, my lord. So along with that matter may come, my
21st of March.
March, my
Okay.
March of that.
May I please your lordship? No, lordship, I find a transfer matter, lordship. Lordship, I leave tomorrow for listing.
Why tomorrow?
Tomorrow, your lordship.
Why?
Lordship, I didn't see her.
What urgency is there? What is the urgency?
Lordship, transfer matter, therefore.
Transfer matter, but
Right.
then what is the urgency there? Friday.
May I please your lordship? Lordship, with the consent from the other side, I beg to mention item number 5. As my senior, Mr. Stigmatic is out of station.
Anybody appearing for
I'm
the
appearing for the petitioner.
Lordship, kindly matter may be taken up on 3rd of April.
Third.
No, I'm not giving a date. I'll list after 2 weeks. Heard, Mr.
A. Ahmed.
A. Ahmed, Leonard Counsel for the petitioner. On request made on behalf of SK Medi, Leonard CGC,
CG, sir.
list after 2 weeks.
Lordship, I further beg to mention item number 7 also. Sir. Consent has been taken. On the other side.
You have taken the consent from Mondal?
Yes, sir.
Okay, on request made on behalf of Mr. SK Medi, Leonard CGC, list after 2 weeks.
Yeah, please, I beg to mention for listing my motion matter on tomorrow, man.
Why? What is the urgency?
Minute
That you want everything tomorrow?
Or day after tomorrow. At Friday, I have some difficulty on our part, man. Therefore,
Friday,
not Thursday.
Thursday will be,
Friday, I have difficulty.
then Monday.
Next Monday is closed, man. Holiday. Okay, person, Thursday, man.
Item number 15, madam. There is a personal appearance of 2 officers of the finance department as well as the irrigation department regarding compliance, madam. The order has been complied with. May I play, madam, in between the admission matters, madam, whenever the AG is on legs in another court, he will be present, madam, maybe called up at that time, madam.
Lordship, may I submit as regards compliance? Although they have given
We
one,
will, madam, consider that when the matter is
yes,
called up.
Lordship, because although sanction has been given to an amount of 27 lakhs 32,369, I have taken instruction from my client in the morning. Lordship, an amount of 2,69,030 301.48 has been received. Maybe he has received. It is shown in his mobile, my lord. That amount has been.
So matter may be called up, lordship will hear both the sides.
At what time? Morning hours. Okay.
May I please your lordship, prayer for listing of an item, WPC. It is a 2002 matter. It is an related to increment matter benefit or under MACP scheme is not given. Kindly give a date for listing.
8 April.
It's Judicial lordship, my lord. My lord, I beg to mention item number 21, my lord.
Yes,
We have circulated an adjournment slip, my lord, with the consent of the other side, my lord. Kindly the matter may be, my lord.
you have 4?
I'm for the my lord, respondent, my lord, respondent to my lord. ONGC, my lord.
Your good name?
HP Gwala, my lord. For Mr. BK Das, my lord, I am appeal.
Okay, I'll request made on behalf of Mr. BK Das. Leonard Counsel for the respond number 2. List when?
This to- After vacation, my lord. After Bihu vacation, my lord.
After Bihu vacation.
My lord.
29th.
My lord. Oblige, my lord.
May I please your lordship?
Oh.
Lordship, I would like to mention for listing of 2 WPC matters.
Oh.
One is for transfer matter, another is removal from service, lordship. The matter may be listed on 1st of April or 2nd, lordship.
We'll have it on 22nd April.
Lordship,
22nd April.
oblige, lordship.
Me, please, your lord. Lordship, yesterday I've mentioned for an item of a listing of a writ petition. Lordship, it did not come in a daily list. Lordship may take this matter at 2 as it is a transfer matter. Lordship, there is an urgency because if the matter won't been heard, then the matter will become infructuous, your Lordship. Lordship may take this matter at 2.
How will it become infectious?
Lordship, as the order says, like immediate transfer. Lordship, immediate transfer before the election, your Lordship. As the senior won't be available this week, your Lordship. Lordship may take this matter at 2.
Okay.
Oblige, your Lordship.
My lord, I have to mention one repetition, my lord, maybe listed, my lord, on any 27 or 28, my lord, as your lordship convenience, my lord, urgent matter.
9th April,
My lord, in the month of March, in this month, maybe, my lord.
not March. March is all full. 9th of April.
Item 1 and 2 of daily list, admission.
Please, your lordship. This item can be taken slightly later, your lordship. Senior counsel is on his way, your lordship. Slightly like 15 to 20 minutes, your lordship.
He wants a passover for the time being.
Time being.
This is that part-heard matter, if your lordship recalls, my lord, that dismissal from service without even an inquiry. So there was no inquiry, there was no departmental proceeding. I was arrested on a certain date, and on the very same date, without even issuing a show cause, I was dismissed from service, my lord.
After some time.
Highly obliged, your lordship.
3 and 4, part third.
Maybe the last location, my lord, there was a direction on IIT to produce the note sheet, my lord.
Oh,
That, my lord,
yes.
wait. My lord, the original records are here. And, we on our part, my lord, that my senior has already completed the arguments in the last location, my lord. We are filing in our written arguments.
What is this?
My lord, it is the note sheets are there because these are not otherwise public documents. So they have probably also not shown it to us. That given in our.
Yes. Mahanda, you're done?
Yes, I have already completed my part, but in fact, I have submitted a written argument. If required another month. So my lord, record is already.
You've given your written argument also?
Not yet, my lord, because the records were forthcoming, my lord.
This is my written argument. Already I have completed my
If
argument.
it can be kept on a short date, my lord, I can date, my lord.
Okay. When do you
In the
want?
meantime, your lordship will have to go through the records, my lord.
Yes. Let me go to-
Any date convenient, my lord, early.
Next week.
Next week.
Because
Next week is a holiday.
yes, next week, only 2 days is working day. Yes, working day.
Huh?
2nd of April.
Okay.
Yes, on that date, my your lordship.
The
Third, let it be on third, my lord.
My lord.
Hearing is enough. Third.
No, third is not a hearing day. তারপর যদি কব লাগে, কব লাগিব নহয়। কি থাকিব তোমালোক মানে থাকিব আৰু। এটা এডভোকেট জেনেৰেল হয় তাই কি কথা?
Hearing যেটা লক্ষ্য।
সেকেন্ডত কব। একো নাই, প্ৰব্লেমটো একো নাই, মোৰো সেইটো নহয়।
the respondents 2 to 6 has produced the reports.
মাথা একটু ভালো
The same is retained by this court. On request made by Mr. P.T. Goswami, the council. List went second.
Oh, second man.
Second.
Much obliged.
Not done. We came this report. If it goes to section also, it's some problem with it. Then we keep it. Do it, sir.
But I'm very sorry, madam. I have missed the mention hour, madam.
Yes.
One matter is very urgent. Tomorrow, yesterday I have filed. Transfer matter. Tomorrow it may be taken as a motion matter.
What is the urgency?
As a transfer matter, whether she is in hospital, in the event that she has been also released also, my lord. So if appropriate step is not taken, the email, anything may happen. Kindly, my lord, tomorrow.
Day after tomorrow, day after.
Thursday, my lord.
Thursday,
Tomorrow is the motion day, my lord.
maybe. Thursday.
Thursday. Obliged.
6.
May it please your lordship, the matter may kindly be passed over for the time being.
Why?
Lordship, learned senior counsel, Mr. K.K. Mahanta is coming in his way. He's stuck in the traffic, lordship.
Okay.
That's all.
8, 9, and 10.
May I please, your lordship? Actually, in this case, senior counsel, Mr. K. M. Chaudhary argued the matter. So he some personal difficulties today. So we adjourn the matter for today. my lord.
When do you want?
This month, March, any day.
March will not be possible now.
The first week of April.
Okay, on request made on behalf of Mr. K. M. Chaudhary and the senior counsel for the petition. It's done. 4:30.
Mention repetition 296122, item number 9, there is an interim order.
Interim order passed in WBC 2961 of 2022 to continue till the next term.
Of license matters.
11.
Lakhs in court number 17, Lordship, DB.
Must be having his junior citizen.
Malhotra is junior also been there with him. I have seen, my lord, that division bench one item is going on.
None appears for the parties. List after 2 weeks.
May I please your lordship? Lordship, in this matter, we need some time to file a rejoinder affidavit. A short date may be given.
Rejoinder affidavit.
Yes.
Which affidavit?
Lordship, they have filed an affidavit. We need to file a reply regarding that.
Who has filed the affidavit?
It is record number 3.
Please.
Mr.
A. Chakraborty.
A. Chakraborty, the government advocate, submits that the respondent number 3 has filed an additional, has filed a counter affidavit. When did you file it?
Lordship, I just not.
Has filed counter affidavit.
Going to file, lordship.
You are going to file or file?
File, lordship. File, lordship.
Register to verify and place the same on. MS.
MS S. Ahmad.
S. Ahmad, learned counsel for the petitioner.
Yes, Lordship.
Press for how much time?
Lordship, 2 weeks time may be
Press
granted.
for 2 weeks time to file reply to the counter affidavit filed by the respondent. Press allowed, list after 2 weeks.
13.
May lordship, please. Lordship, 13 may be closed because kindly go through the prayer portion. Most of the prayer portion has already become infructuous, lordship. Only one point is there regarding the salary. So first, A, B, C, these are the prayer persons. So only survival is B. That's salary for 1 month. That is Not yet given.
From July 2022.
July 2020.
Yes,
That is-
Nayak?
Lordship, this case basically relates to transfer of the petitioner from one place to
No,
another.
that has gone, Lordship.
In the meantime, petitioner has already retired, Lordship. But in between this period, Lordship, one departmental proceeding was initiated against her.
No,
That
proceeding not yet initiated, Lordship, because
Initiated,
listen,
Lordship.
no.
That has been stayed by this honorable court, Lordship. However, although that was not under silence. Now, so Lordship may dispose of this matter.
Yes.
As instructions, Lordship. By
No, not
indicating that-
in with a direction regarding the salary period, Lordship.
What an
My
adjudication
prayer
will
is
require, Lordship.
salary period.
Salary period, what do you say?
Lordship, further adjudication will require, Lord. She was not on duty in that period, Lord.
I was on medical, because some medical certificate is already
Then
given.
we may have to hear the.
October, if it is praised, Lordship, then Lordship will hear. Otherwise, DP is
Only
pending
that
for,
period.
for that period only, Lordship, for unauthorized absence.
You file your affidavits?
Yes, Lord.
So Lordship, this is a communication on March. This is the joint secretary to the Deputy Commissioner here. It is admitted that leave is on a medical ground. This is-
That is the main issue, Lordship, which was, DP was initiated because of misconduct, Lordship, because
No, DP is
in
not.
spite of
initiated.
non,
Lordship, this is
That
the,
other petition is disposed of, not yet, pending.
this is the same petition. Lord.
No. You are saying that petitioner has filed another writ petition.
no.
In the same writ petition, Lord.
This same. Lordship, kindly go through their letter. That is the communication from the government to the deputy commissioner regarding leave period also it remains.
Have you seen this letter?
Little detail, Lord.
Last letter.
5th of March,
This year, Lord.
yes, 2024.
No, Lord.
It's by the General Administration Department. You may not be involved. Who
appear for general admission.
Oh, okay, you also did.
But I'm not.
And address to the district commissioner. Just give him this. You have extra copy?
No, sorry.
Yeah, let him read it. I think this is important.
Very important.
Lordship, one BRS application was there. Initially, she filed BRS. During the process, Lordship, she got a superannuation, Lordship. And she subsequent there to Lordship, she joined her post also. I mean,
That's why, look at that query. Whether she made any application for medical leave. These are the
What?
questions that are being asked to the deputy commissioner.
Whether for medical leave, there should be a DPC, not because we're supporting documents and there, she was in.
Do you have any information on this?
No, Lordship, I have to obtain instruction. Yes, Lord. I can obtain.
And Lordship, moreover, I like to draw your Lordship attention on the order dated 22/12/2013. For conduct of the deputy commission, he was personally present before this court. Kindly Lordship see the order 22/12/2023. What are the direction from this court?
Okay, so far as second question is concerned, Lordship, she has been allowed to go on subordination.
No, that's fine.
And so far as first one is concerned, Lordship, an order was issued by the district administration to appear before the medical board, Lordship, which he denied, Lordship, which he did not appear.
Everything, Your Lordship, initiated as per the ego of the Deputy Commissioner, the District Collector.
Yes. You take some instructions and come back.
Lordship, so far as this,
It's only,
Can I have that letter back? Yeah.
Lordship will decide on next date, Lordship, whether this letter has any reference to this present case or not, any relevance or.
Okay. Mr. H. Rama, the senior counsel, has produced a letter dated 5/3/2024, written by the Joint Secretary to the Government of Assam, General Administration Department, and addressed to the District Commissioner Kacha, Silchar, Assam. Stop. The relevant portion of the letter dated 5th March 2024, reads as under A to A. For Mr. P. Nayak, then the Standing Council GAT, prays for some time to receive instructions with regard to the communication dated. With regard to the communication dated 5/3/2024. Praise allowed. When do you want?
3 o'clock.
Please, after 3 weeks.
It's not my learned senior colleague will furnish me a copy of that.
yes, fine.
I have to retain this letter because he has to type it out.
Lordship, that.
Can you have a photocopy now? Just wait,
Lordship.
just wait for 1 minute.
Item 1 and 2, admission.
Just make 2 copies. Keep one in my file.
The last occasion, my lord. Your lordship has inquired
whether the other two accused persons.
No, not only that, you're also supposed to produce the reports.
Yes. My lord, I'll produce the.
You have the reports
My
today.
lord, I have just received, my lord. But before that, my lord, that article 311 that provide you. My lord, that was, my lord, I was in the midst of the argument, my lord, at that time.
No, after you produce the reports, I'll hear you. I'll hear you properly. I'll give you sufficient time. You produce the report. Today you want to go through the reports.
Yes, my lord. I have just received half an
But
hour.
Mr. A.K. Barwal, Learned Counsel for the Petitioner, Mr. P.T. Fukan, Learned Standing Counsel, Guwahati University, submits that he has just received the reports and prays for some time to go through the same. Stop. Praise a lot. How much time you require?
Matter may come up day after tomorrow, my lord.
Day after tomorrow will be difficult. Many cases are fixed.
28th, my lord, 28th.
Not.
Then, my lord, it can be in April first week, my lord.
4th April.
4th. Yes. 4th. Obliged, my lord. Most obliged.
Order.
Yes, wait. So, copy this. Yeah, put it in the file. Nayak, have you got a copy?
Maybe
Mr. Raman, you can take back your. Okay, yes.
I'm sorry, my lord. Item number engineers, item number 11, my lord. I was not present, my lord. Our name may be recorded, my lord. And if it's already the order has been passed, my lord.
Okay. Your good name?
AK Azad.
Your name is not here.
I'm on behalf of PK Roy Chaudhary, my lord.
Then you cancel that order on request made by Mr.
AK Azad.
A.K. Azad, Learned Counsel, appearing on behalf of Mr. P.K. Roy, Learned Counsel for Petitioner.
Obliged.
After 2 weeks.
Obliged. 14.
Yeah, please, Your Lordship, here the matter pertains to payment of arrears salary and non-practicing allowance to the petitioner, my lord. That is why the contempt has been filed. Lordship, regarding that arrears salary, most for the major chunk of the period has been paid. Only a period in between for 1 year, my lords, between 96 January. Up from
13 months. 13 months.
Yes, my lords, from
97 August.
Till 97 August, my lords.
98 August.
98.
97 August to 98 August.
Nine-
97 August to 98 August.
Yes, Lordship, that period, Lordship, is in question. Otherwise, everything else has been, even the non-practicing allowance has been finalized by the health department and forwarded to the accountant general, my lord.
No, that submission you made
Yes, Lord.
on the 12th to 2024.
Yes, Lordship. Yes, Lordship, now regarding that period, that is a disputed period, my lords, because there is no service record available with the AMCH. I have mentioned it with the authorities also, my lords. Regarding that, they can just place I have asked them to place a order from their end, from where that amount they are disputing, my lords. Otherwise, the honorable court's order has been complied with, my lords. Now, if Lordship allows us the time to furnish that instruction, my lords, because that is a disputed question of fact, because the authorities in the Dibrugarh Medical College have no record of his.
Do you have any records which you can
Lordship,
place?
Lordship, may I make a submission?
Yes.
Lordship, part of that period in contention, I was working in Assam Medical College as professor of medicine. I was working there. I have worked from
Do you have
7th of
That is an
January.
oral statement.
7th of January.
Do you have any records?
No, I did not think that the matter will be raised here. I had no,
Only that
No,
amount is
at
left,
least, do
Lordship.
you have some record to show that you are working in the Assam Medical College?
Lordship, I had taken over SARS on 7th of January.
No, that's why, do you have any records?
No, next time I will submit it, Lordship.
You bring the record.
Lordship, grant us some time. In the meantime, we'll like to place our stand also on record, Lordship, because
There cannot be any problem in that matter, Lordship, because I had taken over SARS. Lordship, another thing, Lordship, may I make a submission? Lordship, the date on which the order was passed, from which this contempt case has arisen, it was on 8 March 2019, Lordship. This is more than 5 years, Lordship.
Yes.
It is more than 5 years, Lordship. And then the original case from which the order had arisen, that was started in 2014, Lordship. So this is 10 years, Lordship.
Lordship, here.
And Lordship, I am a retired person.
No, Lordship, here there was non-cooperation on the part of the
Lordship,
petitioner also, because of which a lot of his documents could not be found. So Lordship may put this address this issue on the next date, because there was non-cooperation. He has still not visited the authorities. It is after we persistently pursued him, that is when the petitioner had supplied the documents and the relevant signatures for which, after which we could process the documents, Lordship. So Lordship may keep this question open on the next date, and that can be.
Okay, heard Miss Dr. D. Laskar.
Lordship, may I make a small submission?
Petitioner in person.
Lordship.
Yes.
Even on 21/11/2022, the order passed by this honorable court on this case, on this contempt case, on 21/11/2022, the order
No,
number 7.
This
In that
court is
order
asking
also.
you one question.
Lordship.
Do you have any documents, any records that for these 13 months you were serving in the Assam Medical College?
Not the entire period, part of
Yeah,
that,
that
about
is
7 or
these are
8
the
months.
disputed
7 or 8 months I was.
And the other periods?
Other period was regularized subsequently by the government of Assam, Lordship.
You have
That
all-
period he has been paid, Lordship.
This 13 months I'm talking about, 13 months.
Yes, that's it.
You are saying about 7 months you were in the Assam Medical.
Assam Medical College, Lordship. From
the other-
January till August. About 8 months, Lordship. About 8 months I was in Assam Medical College.
And the other 6 months?
They have their records, Lordship. If they don't have the records, then who will have the records? I was working there.
Mr. Dr. D. Laskar, petitioner in person. Mr. H. Alial, the counsel appealing for the respondent, submits that appropriate orders should be passed by the respondents with regard to the 13 months period for which salary has not been paid, for which error salary has not been paid to the petitioner. Stop. He therefore prays for some time. When do you want?
Lordship, after 3 weeks, in the meantime,
Why 3 weeks?
Lordship, I can place after. Lordship, I can place it.
And therefore praise, don't say praise, but sometime. Praise for how much time?
19th. Lordship may fix it in first week of April.
Praise for 2 weeks time. To receive instruction. List on. When do you want?
Lordship, first week or any date after first week of April. First week.
8 April.
Lordship, with non-practicing allowance, Lordship, it is also 5 years. That matter is also being going on.
Non-practicing allowance, we were able to finalize after he produced the necessary documents.
No, you said you have sent it to the Accountant General.
Accountant General, yes, Lordship.
Accountant General is a party here?
No, Lordship.
No, not a party.
He has not, Lordship, there is an amicus curiae also who was appointed, who has not been coming, because of which lot of necessary parties have not been made a party, my lords. Petitioner is appearing in person, that is the difficulty we are facing.
Where is the order passed by this court?
Lordship, page 17 of the contempt petition. The operative.
Page 17, that is the page number 17 of the contempt petition.
Point 2, Lordship.
Annexure 2, Lordship.
Accountant General was not a party in
No, was not a
the
party.
main writ petition.
Yes, my lord. Now he has not been made a party, because of which regarding non-practicing allowance. But he is.
Lordship, may I pray that the
Lordship may direct the amicus curiae in one of the orders. The
honorable-
amicus curiae was also asked to be present, my lords, in order to assist the court.
Lordship, may I pray that the honorable court will add Accountant General as a
That
party.
we can't do. You'll have to make an application. You'll have to make an application. Do you require the assistance of an amicus curiae?
There's already one appointed.
Lordship, but
But,
he
why he is
was
not present is.
he was. I mean, he was appointed, but he hasn't come. Lordship.
Actually, that is, may record a statement.
Who's the amicus curiae?
Mr. Advocate, Mr. Suman Chakraborty. Lordship.
By which order he was appointed as amicus curiae?
I think. I think second last.
Which order?
Yes. Limited date. Honorable Justice Shuman Shah.
Honorable Justice Suman.
And
No, Honorable Justice.
Justice Shuman Shah asked the amicus curiae to be present, Lordship. It was, I think.
It was appointed by Honorable Justice.
And
Sumitra.
Justice Sumitra Soikia had appointed the amicus curiae.
S. Chakrabarty.
Yes, Lordship. S. Chakraborty, Lordship. He appeared also in one of the.
Once he appeared once.
The learned amicus curiae. Mr. S. Chakrabarty is also directed to be present in court on the next reasonable date.
Date.
8 April. 8.
16 hearing.
In this case, my lord, on the last occasion, I was directed to seek the instruction as to whether the suspension period was revoked. But I have been informed, my lord, and also from perusal of the record, it was not revoked, my lord, because if my lord may kindly peruse the order at page 32. Second parameter. Just getting no other alternative, my lord. First, third, fourth line from down, my lord. At the second paragraph, getting no alternative, he was placed under suspension with effect from 11/12/15 for his unauthorized overstaying leave with effect from so and so, while office memo number so and so, and an order was issued to draw up a departmental proceeding against a delinquent constable. Thereafter, this order does not mention anything about whether that.
Yeah, that's why this court wants.
Yeah, there was not.
Do you have
revoked, my
any
lord.
instructions?
No, I have not received any instruction.
That was not revoked, my lord.
Why can't you get the instruction? It is a
But,
simple instruction that this court wants to know.
Last occasion, my lord, I have received a record only. The expertise inquiry was done. He was
No, no.
authorized absent.
This court wanted to know whether the petitioner was under suspension when the discharge order was passed.
Yes, sir. I will obtain it for next week.
How much time will you require?
1 week, but I will get it.
I'll fix a date then. But as counsel for the petitioner. Mr. T.C. Fidel and additional senior governor. Place for 1 week time. To enable him to take instructions. As to whether the petitioner was under suspension. When the discharge order was passed. So. List on after 1 week.
After 1 week, my lord.
That will be February, April.
April.
1st April, my lord, or 2nd April, my lord.
2nd of April.
2nd of April.
2nd of April.
2nd of April. I will obtain.
7.
Problem.
Seventeen.
Please, Your Lordship, kindly the matter may be passed over for the time being, as my senior is on leg.
Yes.
Lordship, record has not come, Lordship. So 1 week time, Lordship. 1 week time may be granted, Lordship.
My senior.
Let him get the records. But MS?
B. Hajarika.
B. Hazarika, that is also. Appearing on behalf of MS R. Chowdhury, the records for the Mr. Chakrabarti, then the governor, it went for weeks time to enable him to produce the records. Not. List on. 9th April.
Bless.
Obliged.
15.
Yes.
15.
15.
Lordship, I am appearing on behalf of the Respondent number 8, the Commissioner and Secretary of the Finance Department. এখন extra copy দিয়ে দিও।
Yes.
We have filed an additional affidavit bringing on record.
Where is that additional affidavit?
It was filed. It was filed yesterday, but we have extra copy, Lordship. Please to Pedro.
Have you given the financial clearance?
Yes, everything, Lordship.
Have you got it?
So making my
They will
submission.
definitely get the.
Lordship, just now I have
Let them
taken
test the case,
instruction.
Lordship, then.
Just now I have taken instruction from my client. Only an amount of, my lord, 2,69,301.48 has been received by him.
Finance Department gave clearance. Let us place the case, Lordship.
Yes.
Page 57. Page 57, 15/3/2024. In compliance,
57.
page 57, Annexure B. I've got Lordship.
Yes.
In compliance of the Honorable High Court's order dated 22/2/2019 and 8/4/2019, passed in WPC so and in pursuance of the letter dated 15/3/2024, the Government of Assam in Irrigation Department, Bhuban Chandra Das Masteral is hereby appointed in grade 4 of helper under Golaghat Purupothar Division for purpose of regularization of his services with effect from the date of regularization of his service of the Bhuban Chandra as per earlier regulation order dated 3/10/2005 until further orders and in the prevailing scale of so plus other allowances admissible under the rules subject to subsequent revision as per ROP. This appointment is treated as special case under a special circumstances in compliance of the Honorable High Court's order dated so is not to be taken as a precedent in other similar cases. The post is personal to the incumbent concerned and same will be abolished as soon as concerned incumbent relinquishes his post in any manner. Further, it is to be mentioned that in terms of the Honorable High Court's order dated 22/2/2019, the incumbent after regulation shall be entitled to arrear salary with effect from 13/7/2017, that is date of filing of his writ petition, after adjustment of the wages already drawn by the incumbent. So this is regarding regulation and all clearing. Next page, Lordship will kindly come. From Finance Department, we have written to the Accountant General Assam, same day. Creation of post for regulation of service of Bhuban Chandra Das Master Roll Workers engaged with and in continuous
Where's
service.
that page?
Page 58. So the Finance Department Deputy Secretary, Finance Irrigation Department wrote to the AG. Creation of post for regularization in service of Bhuban and its continuous. Here I am directed to convey the sanction of the Governor of Assam for creation of one number of grade 4 posts under Golaghat Pothar Division for the purpose of regularization of services in respect of Bhuban Chandra Das
who was engaged prior to 1/4/1993 and still working in the irrigation department without any interruption or break in service with effect from the date of regularization of service of Bhuvan Chandra Das. Under erstwhile Golaghat Division, by order dated 3/10/2015 as per Annexure A. This post shall be personnel to the incumbent concerned holding the post and shall be abolished as soon as the concerned incumbent relinquishes the post in any manner. The post shall not be filled up by any person. This should be treated as a special case. This has the concurrence of Finance Department later dated 14/3/2004. E-file number so and so. Last line. Next page now, Lordship. Regulation Master look at Annexure A, page 60 is the pay scale, etc. Now coming to page 61. 15th March, Irrigation Department. I am not representing the concerned contempt of irrigation, but still for Lordship's consideration, I am placing it. Now, Irrigation Department wrote to the Accountant General, drawing of area salary DA in respect of Bhuvan Chandra, etc. in case now code number so and so. Government Regulation Order dated 15/3. In inviting a reference to the letter cited above, I am directed to convey the sanction of the Governor of Assam to the drawal of area salary DA for an amount of 27,32,369 for the period with effect from 26/7/2013 to 29/2/2024 in respect of Bhuvan Chandra Das of Golaghat Korupothar Division in compliance of order dated 22/2/2019 passed by Guwahati High Court. So the amount is 27,32,32,369. And last line, this has the concurrence of Finance EC Department dated 14/3/20. So everything has been done. So now the AG office will process and give this amount. The sanction, whatever role we have to play on part of the irrigation department, on part of the finance department, it has been done. The AG office will now do the needful, the further action. So they will get this amount. The amount has already been sanctioned. Has been sanctioned.
Lordship has been sanctioned, but when they'll release, I am told by my client, my lord, it has been informed by the officers concerned that there is no budget. So for this reason, only 2,60,000. Now he'll run after again.
That we don't know.
Lordship.
As per the documents enclosed, the sanction order is there.
Sanction order is there, your
No,
lordship.
it has come to
But
the-
what the lordship concession made by learned senior friend on the earlier occasion that it would be complied with within a period of 1 week. Lordship, 1 week has gone by. Lordship, they have not done substantial compliance, and in violation, lordship, it would be in violation of Section 12 of Contempt of Courts Act, my lord.
No, I don't think so.
Lordship, can they have a look?
Look at
Last order.
Look at
I have, Lordship, I have gone
Have
through.
you-
They have served copy on me. Lordship, 27 lakhs. And your lordship will kindly note one factor.
Now they have sent it to the office of the AG. Now AG will have to respond.
AG will, what they will do, they will assess everything, the amount is there, and they will write to the DDO Golaghat for release of the amount. This is the procedure. It
Lordship,
happens with every case.
AG is a party here.
AZ is not as the content application, my lord. Finance was a party.
Was
2 days ago, AG got
a
this.
was AG a party in the writ petition?
Writ petition, let me have a look, my lord. Purana, Purana?
Nah,
I don't
I
think.
can't say party.
Finance department is a party. Let me have a look, my lord. Treasury office is
AZ
a
is not a
party.
party.
AZ is not a party. Let me have a look. Purana file ka
So this is a routine affair, Lordship. They will get it.
Lordship, why I'm making the submission? My client is without any wages from last 2013. Lordship will kindly consider his pathetic condition. He has landed.
That's what they've done
My
now. The
lord.
sanction of rupees 27 lakhs and some oath has already been given. It's sent to AG. Now AG will do the needful.
Lordship, let the matter be kept pending, my lord.
But we
Lordship,
can't have the personal appearance of the respondent present anymore.
Lordship, unless, Lordship, again, I have to run after the officers concerned, my lord.
According to this court, substantial compliance has already been.
Only sanction was for 27 lakhs and Lordship, only 2 lakhs has been released. The Lordship will kindly.
That is a different.
My
thing.
lord.
This sanction order on the face of records, they've complied. Do you have any grievance against this sanction order?
I don't have.
You don't have.
Whatever.
So you've got it.
No, Lordship.
So you'll be
No,
getting
no,
it.
but the amount has not been has not come to my account. That is my,
So that the accountant general will answer why it has not been, what they have done after they got this sanction order.
let the matter be kept pending, your lordship, contempt be kept pending. Regarding the personal appearance, I leave it to your lordship's discretion, because they have issued, at the face of it, they have issued order, although money has not been debited to my account, my lord. So lordship, may I pray, your lordship, matter may be kept, may be taken up in the first week of April. In the meantime, as they've submitted, my lord, it would be complied with, and after necessary communication.
Unless the accountant general is present. Now, we don't know what they are
Lordship may
doing.
direct the officer.
So far as the state respondents are concerned.
Yes, my lord.
The contemners are concerned.
My lord.
They've done their part.
Let AG be made a party here in the contempt case, if they are so skeptical and
So the
apprehensive.
issue is that AG is not a party. in
Yeah,
the
let them make them a
Because
party in the
finance
contempt case.
department, now it has come up, that issue has come up,
Only
my
2
lord.
days ago, everything has come to this position. Today is 19th. This letter was written on 14th and 15th. So AG will take some time. This is a normal course, lordship. Nobody is going to run away and nobody is going to.
Because my lord,
give
4
any
person,
false
that's why
statement
I'm
to the
submitting. I
honorable
don't have any other.
That we understand,
My
that we
lord.
understand.
The person standing on the last row of society, my lord. He has got
That-
justice before his
That we
honorable
have
court, my
understood.
lord.
That we know.
If they go to
But the
the extent, lordship,
court also has its
Lord,
limitations.
I understand. Lordship, so may I make a
Especially-
submission, my lord?
Especially in contempt.
Yes,
case,
my limited. power.
Very limited
No, sh-
in contempt jurisdiction.
My lord.
Now we have to see whether they have complied with the order.
My
There are
lord.
2 orders, one regularizing you,
Yes.
once.
Yes, they have done so.
Sanction.
But since the money has not come, so may I pray your lordship, let the matter come out first week of April. In the meantime, if required, I'll make AZ a party respondent in a contempt application.
Third MS B. Boyan, then a senior counsel, accepted by MS S. Bora.
B. Bora.
B. Bora, general counsel for the petitioner. The respondent number, who has filed this additional affidavit?
respondent number.
The respondent number 8 has filed an affidavit in opposition. Wherein at annexure
B, page 58.
annexure, what is this?
Annex, page 58, annexure C, 15th March.
C, no, annexure C.
Sorry, page 57, annexure B. That is the regularization order.
1 minute. It is not very legible here. That's why I'm asking.
Lordship, yeah.
The annexure C.
Annexure B, page 57. This is a much clearer.
Where? An order dated 15/3/2024. Is annexure B, by which the petitioner is appointed in the grade 4 post of helper under Golagat Desh Sarupathar division within bracket irrigation, Golagat, for the purpose of regularization of his service with effect from the date of regularization as per regularization order dated 3/10/2005 until further orders. Stop. Another communication dated 15th March 2024, written by the Deputy Secretary within bracket E to the Government of Assam, Irrigation Department, and addressed to the Accountant General Assam is annexed as annexure C, where the Office of the Accountant General Assam. No, don't say where. Conveying the sanction of the Government of Assam for the creation of one number of grade 4 posts under Golakat, there's Sarupathar division within bracket irrigation, Golakat, for the purpose of regularization of the service of the petition. Stop. Also petitioner, stop. The respondent number 8 has also enclosed another communication dated 15th March 2024 as Annexure D, wherein conveying the sanction of the governor of Assam for withdrawal of air salary, /DA, etc., for an amount of rupees 27,32,369 to be paid to the petition. Stop. On a perusal of the aforesaid annexures B, C, and D, this court is of the considered opinion that substantial compliance has been made by the respondents and therefore has been made by the respondent. Stop. However, on the prayer of MS B. Buyan, the senior counsel for the petition, please the matter on when do you want?
10th of April.
10th will be difficult. 9th of April. The personal appearance of the respondents
8 and
9 are dispensed with.
highly obliged.
Do you have?
We have, Lordship may be pleased to keep it on record. We'll have.
I'll keep it on record,
Yes, sir.
just in case on the next one.
Deeply obliged.
19, no?
Hearing.
May please. Petitioner was serving as a civil engineer in Grace Mellor. I'm just giving the outline. I'll come to the list of date I've given Punish Mellor. Now, he was in probation, my lord. At that point of time, it came to light that a minor criminal proceeding was pending against him. So on that basis, the impugn order has been passed on the allegation that petitioner deliberately suppressed this fact from the authorities. This is the general outline of the facts, madam. Now, my contention will be twofold, my lord. First thing, from record, I'll show that I had no knowledge about this. And second thing, my lord, Supreme Court has laid down a guideline, my lord. I have given a judgment, my lord, there. The authorities, while taking a decision on my termination, did not consider the Supreme Court judgment, my lord. Supreme Court says that, my lord, if it is a small, tiny matter, if he is very young and all, this cannot be, even if it is assumed that he deliberately suppressed, even then this cannot be a case for termination, my lord. If the cases are minor cases, my lord. So I'll come to that, my lord. One list of dates I have given, my lord. Has your lordship got it, my lord? On 13/4/2016, the petitioner, after being duly selected for the post of junior engineer civil GREF, was asked to report on 25/4/2016 to GREF Center at so-and-so place. That will be annexure 1, so-and-so, my lord. On 26th of April 2016, the petitioner was appointed to the post of junior engineer so-and-so and was placed on probation for 2 years. That appointment order, they have enclosed, my lord. That will be in page 496. They are, my lord. During police verification, it came to light that an FIR was filed in so-and-so police station at Uttar Pradesh against the petitioner and his family members. Now, Lordship, can you turn to, my lord, FIR, my lord, for a moment, my lord. Page 17
of the
writ petition, my lord. Annexure 2.
Sure.
Annexure 2, my lord. Page 17.
This has been lost by a number of informant, my lord. That name has been mentioned, my lord. May I read it, my lord?
Yes.
With due respect, that yesterday, dated 13/7/2014 at about so and so PM, I was at my home. Before that, there was little bit of argument between informant and Mrs. So and so, wife of so and so. The argument was already over, but so and so called her husband Binod, son of so and so, through mobile, and her son Dhananjay. Dhananjay is the petitioner, my lord, and Rajnarayan, and started narrating false story with some extra salt and chili. And after that, Ganpati, Vinod, Dhananjay, and so enter into the informant's house forcefully and pulled her by hair and threw her on the ground and beat her. Her brother Abhishek, at the rate so badly with hands and legs. Hearing hue and cry, neighbors of the locality rushed to her house and stopped their fight by interfering. Thereafter, Binod and his family left the place and using slang words and so and so. So this FIR was registered initially, my lord. As you kindly see, 323, 504, 506, and most importantly, my lord, 450, my lord. This case was registered under section. You will find it page 18, my lord. The sections are given, my lord.
Where are the sections?
Page 18, my lord. Charge.
Yes.
Charge sheet, lordship, can see. Charge sheet dated number so and so, dated so and so. We were the accused, my lord. Binod so and so, so and so. Dhananjay is the petitioner. Dhananjay is there, my lord. So hereby request that on the basis of information, it is so and so, Ghosi petition has been registered under 323, 520, 520, then, sorry, 204, against so and so, so and so, so and so, my lord. PS Ghosi, so and so, so and so. The case was investigated properly, and during investigation, no material, that should be important, my lord, has been found under section 452. The case was investigated under 303, 504, 506 of IPC. The statement of the witness has been recorded during the investigation of the offense, and after that, the accused were charge sheeted under 303, 504, and 506 IPC, and charge sheet filed before this court. It is therefore requested the honorable court to call for the so and so, my lord. So 452 is not there. Now, so for the other charges that concern, my lord, these all the charges are bailable charges, my lord. 322 is simple hard. This is 1 year is the maximum punishment. 504 is insult, only insult, my lord, 2 years punishment. 506 is criminal intimidation. But 452, which was originally there, my lord, the charge was trespass and preparation for assault. That is a serious offense, my lord. That punishment was 7 years. So every time your lordship will come to know, my lord, when imposing penalty, the authorities time and again took clarification from the police officers whether 452 was there. Authorities, police officers always confirm that 452 was not there. Even then, my lord, while imposing punishment, they have taken into consideration that 452 was there, my lord. Total non-application of mine, my lord. So it was a minor case, my lord. 452 was removed from the charges, my lord. And in the ultimate judgment, my lord, lordship may kindly come to the judgment, my lord, for a moment.
Page?
I'm coming, my lord.
From page 26.
Page 26. Has the lordship got it, my lord?
Yeah.
Page 26. The present case has come for trial before the honorable court after filing charge sheet by so and so against accused person for taking cognizance and so and so. In short, the case of the informant is that is the FIR, my lord. Lordship may skip for a moment, my lord. 2, 3, lordship may skip. 4 will be relevant, my lord. 4 onwards, I am reading, my lord. After taking cognizance on the basis of the charge sheet, the record has been sent for preparation for duplicate. Summons has been issued against the accused person for trial. The accused appeared before the honorable court, and copies of the all relevant document of the case furnished to him under section 207 so and so, and the charges have been explained to them. During trial, at the evidence stage, prosecution examined 5 witnesses at serial number so and so. FIR is exhibited at so and so, so and so. Then paragraph 7, my lord, statement of the accused person recorded under 313. 8, learned public procedure that can be skipped, my lord. Then this is settled principle of law that the accused are innocent till they are proved. In the present case, the prosecution must prove the case beyond all reasonable doubt that on 13/7/2014 about 7:30 p.m. the accused have beaten the informant with the hands, legs, and so and so, so and so. Prosecution witnesses are so and so. Now, Lordship, kindly see the prosecution witness who filed the information, what they are saying before the court, my lord. With PW1, she was the informant, my lord, stated in examination in chief that a so and so at about so and so informant was at home. Before that, there was little bit of argument between the informant and so wife of Vinod. The argument was already over, but so called her husband Vinod, son of so through mobile, and her son so Dhananjay, and so started narrating false story with exaggeration. And after that, Ganvati, Vinod, Dhananjay, and Rajnarayan entered into the informant's house, and by hearing hue and cry of their neighbors and the locality rushed to the house. It was dark night and there was no light. At that same time, someone pushed me behind my back. I fell down and got hurt. Accused Vinod, Dhananjay, so and so, neither beaten me nor my brother or sister, nor used any slang words against us and threatened us to kill. I have filed the FIR on instigation by the villagers. Then PW2, my lord. PW2 is another informant who signed the FIR, my lord. PW2 has stated in his examination in chief that 2 years ago from today, Vinod, Dhananjay, and Rajnarayan, so and so, neither beaten me nor my brother and sister, and not used any slang words against us and threatened to kill us. I got hurt due to falling down. IO has not recorded my statement. Number 3. Number 3 is another person, my lord. Babban Yadav stated in your examination in chief that he was not present in the time of so and so. When I reached there, dispute was over. The accused Vinod, Dhananjay, so and so did not beat the informant and our family members, did not use any slang words against the informant and threatened to kill. It was only an altercation in the courtyard, my lord. The informant themselves, they are saying, my lord. Then PW4, my lord, 4th line I'm reading, my lord. The accused Vinod, Dhananjay, so and so, neither beaten me nor my brother, sister, nor used any slang words against us, not threatened us to kill. I got hurt due to falling down. Number 5. 2 years ago from so and so, the accused Vinod, so and so had beaten he is only saying, my lord, had beaten informant and her brother, sister, and used slang words. He is another person, my lord. During cross-examination, he has stated that I have reached the door of the informant at about 8 p.m. Much after the Karel murder, both the parties were injured. The accused Vinod, Dhananjay, so and so, did not beat the informant, use slang word, and threatened to kill so and so. In the cross-examination, he has said that nothing happened, my lord. So finally, my lord, last paragraph, my lord, penultimate paragraph. After going through the facts and circumstances of the case, the prosecution argument and the evidence of the witness are contradictory to each other. It is opinion of the court that prosecution has failed to establish the charges framed against the accused person beyond reasonable doubt. Accused are entitled to be acquitted on the benefit of doubt, my lord. If this benefit of doubt, my lord, I have placed a judgment other day, my lord. It is Bombay High Court decision says that whether the acquittal was free from all reasonable doubt or on benefit of doubt, for that the entire judgment has to be read. Now, I have read the judgment before Lordship, which says all the prosecution unequivocally says that there was nothing happened, there was only an altercation, my lord. So in that view of the matter, my lord, this last word, that benefit of doubt, is absolutely, there is a judgment of the Bombay High Court, my lord, I placed on record other day, by hearing stage, my lord. It says that entire judgment has to be read, my lord. I'll place that before your Lordship. Now, I'm coming back to the, now this shows that it was a trivial case of altercation. Finally, I got acquitted. Now, the question is, my lord, whether I had knowledge about this case. And they said that having due knowledge, my lord, I did not place it before the authorities while I was put on probation. Now, I'm coming to that, my lord. First, may kindly turn to the list of dates.
Yes.
FIR I have read, my lord. Then charge sheet file I have read, my lord. Then
1 minute, 1 minute.
first page, my lord. (15/7) FIR was filed, my lord. That I have-
1 minute. You want bail?
That time.
Yes.
Yes, immediately bail I have enclosed the order also.
And how do you say you are not aware of the FIR?
Exactly, my lord. And that's why I'm coming to the list of date, my lord. When at the time of probation, police verification is made. When it was detected that one case is pending against me, that it was informed. Immediately I came, and not only me, my lord, my family members also did not know, because it was only a bailable offense, my lord. They have filed charge sheet and no notice, my lord. I immediately, Lordship may kindly turn to my affidavit in reply. I have given a date chart, my lord, from the record.
Anyway, you proceed according.
Yes, sir. That will be
That
bail onward, I know. Then after I came to know, I have taken bail, my lord. Thereafter, I know, my lord, everything. They are saying that when I was given appointment, it was in my knowledge. My case is that when they have said that a criminal case is pending, immediately I asked my family members of the 4 members are there accused, all have taken bail together, my lord. It is not that family member took earlier. That time also I would have knowledge. The family member is having knowledge. It didn't happen, my lord. We have taken bail together, my lord. I have given a date chart that will clarify the thing, my lord. And the order also. Now, the list of date, my lord.
Oh.
FIR I have read, my lord, just now. Annexure 2, my lord. Then charge sheet I have read, Annexure 3, my lord. Then petitioner and his family members were not aware about the registration of the police case and filing of the charge sheet. Having come to know about it, all of them appeared before the learned single judge and obtained bail. The family members of the petitioner appeared before the CJM, Mo, and so obtained bail. Then the petitioner filed application and obtained bail. That will be Annexure 4 and 5 at page 22 and 23, my lord. May I take your lordship to that page, my lord, that bail order, my lord, or
page
22 and 23, my lord, of the petition.
Yes.
This is the bail petition I filed, my lord, on 4/8/2016. This is my bail petition, my lord. Then 24, lordship may kindly say. On 4/8/2016 itself, the bail was granted. Under the facts and circumstances of the case, it is in the opinion of the court, there is an applicable ground for allow the accused to go on bail. This is my case, my lord. Then within 2-3 months, the trial was finished, my lord. The judgment was passed on, that I have read, my lord, on October 2016. So within 2 months, my lord, the trial finished, my lord. 1st October. Now here, my lord, lordship may kindly turn to my affidavit in reply, my lord. That page I have mentioned, my lord, 102. That paper book page number, my lord.
Oh.
I have given a date chart. 10/12/2014, charge sheet filed by the police in the court. 16/6/2015, summons issued to the accused person. Then accused absent, accused absent, accused with bailable warrant was issued. Then accused absent, bailable warrant was issued. And 2/8/2016, accused Vinod Rajnarayan Gyanvati appeared and granted bail. Other family members. Just after 2 days, my lord, I was coming from my place of posting. So after 2 days, accused Dhananjay appeared and granted bail. Then summons issued and all, my lord. Then judgment was produced within 2 months, my lord. Not even within 2 months, my lord. 1/10/2016. So, and this is not disputed, my lord. First thing first, it was a very petty case. Second thing, I was totally acquitted Thirdly, my lord, I had no knowledge, my lord. It is not a fact that my family members took bail earlier and I have taken in some manner, my lord, I have taken it later. It's not that. Me and my family member, when they came to know, immediately they have taken bail. On 2nd of August, they have taken bail. On 4th of August, I have taken bail, my lord. Well, I was coming from the place of posting, so that's why 1 day's delay, my lord. Now, Lordship may kindly turn back to the paper book, my lord. Almost I have finished, my lord. Then 4/8/2000, my lord, bail application I have read. Then judgment I have read, my lord. Then now Lordship kindly said that the authority made some inquiries. 12/11/2016, the police verification report filed as regards petitioner stating about his acquittal in the case. Lordship may kindly see it for a moment, my lord. Page 34.
Of the writ petition.
Of the writ petition, my lord. Police verification report, my lord.
Yes.
My lord. I hereby inform that your VR number so-and-so with respect to Dhananjay Kumar Yadav, resident of so-and-so, verification conducted and has come to light during the investigation when visited the village. So-and-so and gone through the register number 4 and 8 maintained by the local authority that a criminal case was registered against the applicant in Kosi Police so-and-so and disposed of on 1/10/2016. Applicant was acquitted by the CGM and at present there is no criminal case pending against the applicant. Otherwise, his reputation is good. This is the police verification report, my lord. Then a query was made, my lord, specifically because 452 was a serious charge. So authorities wanted to know whether 452 was there in the trial or not, my lord. That your lordship will find at page 8, my lord. Annexure 8, page 36, my lord. It is intimated that as per CGM's so-and-so, dated so-and-so, received by your office manager so-and-so, Dhananjay Kumar Yadav, so-and-so, of village so-and-so, has been set free from the charges from 323, 504, 506, which were registered against the individual, but no decision regarding the case under section 452 has been mentioned in the EBIT code order. As per remarks of the inquiry officer, charges under section 452 so-and-so were pending against the above named individual so-and-so. This unit had requested your office to confirm whether the case under section 452 registered against the above named employees is cleared or still pending. But still, after going through the judgment, they were not convinced whether 452 was there or not, my lord. Even from the charge sheet also, they were not confirmed 452 was there or not, my lord. So they wanted a clarification on this, my lord. Now, next page, my lord, page 37, lordship, it has been clarified again, my lord. By the police at Ghosi to the superintendent of police, my lord. Last two line will be suffice, my lord. Initially, section 452 was registered against the applicant, but during the investigation, the same was struck off due to lack of evidence. There is no criminal case pending, so. So this was clarified by the OC to the SP. And again, my lord, page 39. As you got it, my lord. Verification report, again, it is mentioned that, my lord, PS at serial number 7, PS case number so-and-so, 323, 453, so-and-so was registered, but during investigation, 452 of IPC was struck off due to lack of evidence. Applicant was acquitted under section 323, 504, and 506. Now, annexure 11, my lord, I filed an affidavit before the authorities, page 41, my lord.
Yes.
Para 4 will be relevant, my lord. I, Sri Dhananjay Kumar Dada, do hereby declare that prior to July 2016, the deponent had no knowledge about the pending GR case number between the state versus so and so, so and so, so and so. So this was not in my record. I have sworn an affidavit, my lord. Now, Lordship may kindly see now, after this, my lord, they have taken a decision to terminate my service, giving a notice of termination under the relevant act, my lord. Now, what transpired in their minds after all this verification, still 452 was hovering in their mind, my lord. They could not get out of 452. Now, Lordship may kindly turn to page 89, their affidavit, my lord. Annexure E of their affidavit, page 89, my lord.
Yes.
Second paragraph, my lord. Carry an antecedent role. This is the foundation of their decision, my lord. By this, they have taken a decision to terminate my services. It is submitted that so-and-so Dhananjay Kumar Jadhav was appointed on so-and-so and posted on so-and-so. Character and antecedent role of the in respect of the above was forwarded to the district magistrate so-and-so center for verification and endorsement of remarks of page in para 3 and 4 verification rule, letter number so-and-so, dated so-and-so, had intimated that character and antecedent role had been received, duly verified by so-and-so, so-and-so, nil. And as per remarks of the SP so-and-so, so-and-so, on page number 4 or verification rule, a criminal case bearing so-and-so, so-and-so under section 452, 323, 504, 506 of the so-and-so was pending in the Honorable Court of so-and-so against the individual, and therefore they have not considered the above so-and-so for service in the department. It is submitted that as per the declaration made by in the attestation form of the individual at the time of appointment, he had given a false declaration that he was not involved in any criminal case, whereas a criminal case bearing so-and-so section 452 already pending. 452 did not go out from their mind, my lord. So 452 was taken into consideration. On receipt of the information, GR so-and-so had taken up the matter with the headquarter number so-and-so. Accordingly, case was further taken up on so-and-so, seeking advice on further course of action. After obtaining opinion from so-and-so on the matter, the case had been examined by so-and-so, dated number so-and-so, 17 July, as intimated that the competent authority issued direction that the above individual is liable to be considered for termination from service as per Rule 5 of CCS Rule 1965.
Where is this rule?
This rule, my lord. I'll come to this rule, my lord. This rule specifically says that this is applicably, it's mentioned, my lord, it's a temporary services, TS. I'll place it on record, my lord. This is not applicable to me. The temporary service has been defined under the Act, my lord, and there is a government notification that for a probationer it is not applicable. I was inducted in service after a due selection process against a permanent vacancy. I was placed under probation. So temporary service rule is not applicable. But temporary service rule is a shortcut. Just give a notice. After 1 month, you will lose your job. No inquiry, nothing, my lord. So they have taken recourse to this, my lord. That is also illegal. I'll come to that, my lord. While making submission, my lord, I'll place that before your lordship. Paragraph 9, my lord, as per instruction contained in so-and-so, rule so-and-so, when an action is taken under section 5 to terminate the service of a temporary employee, the order of termination, which should be passed by the appointing authority, should not mention the reasons of such termination. So reasons of termination has not been mentioned in the impugned order, my lord. So this is the foundation they have taken into consideration. Still, after so many clarifications, my lord, still they say that 452 was there, my lord, because that was a serious offense, my lord.
Yes.
So thereafter, it followed the notice of termination. So I'm coming to that, my lord, straight away, that is the impugn order, my lord, page 48 of my writ petition. Without assigning any reason, any opportunity, my lord.
Page
48, my lord. Notice of termination under section 5(1) of the CCA rule issued to so by the competent authority with effect from 27th October 2017, received so and the same is hereby served on you, dated so. Then next page, my lord, in pursuance of section 1 of the or rule 5 of the CCS temporary service rule, I see so hereby give notice to Dhananjay Kumar that his service shall stand terminated with effect from the date of the expiry of the period of 1 month. This is under challenge, madam. Finally, this is the impugn order, madam.
Both page 48 and 49.
48, 49, madam.
Two impugn orders.
Madam, this is the communication, and this is the I think they have enclosed the thing, madam. On 27 October, that order was passed. This was communicated by 15 November, madam.
Oh?
This order was passed on 27th of October, madam, 2017.
Oh.
And this was communicated next month, my lord, on 15 November, my lord. So page 48 is the communication order. Actual order is, my lord, page 49. Here your lordship will find no reason has been assigned. Although, my lord, there is also one ground, my lord, although it's a stigma on me, my lord. On some allegation they are terminating, they ought to have held an inquiry. I'll place a judgment on that, my lord. This is also one of my grounds, my lord. So facts I have concluded, my lord. I'll just yes, madam. Now, my first submission before
5 minutes.
Madam. The written submission I have given, my lord. The grounds I have taken basically 3 grounds.
Submission.
I have just read over, my lord. That page 4. These are the grounds I have taken, my lord. I just place 2-3 decisions, my lord. The first thing is that petitioner had no knowledge about the criminal case while signing the declaration. Therefore, there was no willful separation on his part. The impugn action in issuing the notice of termination is therefore illegal and arbitrary. That I submitted before lordship that I had no knowledge, my lord. First thing. The second ground is that in the matter of separation of facts regarding criminal case and or conviction of the incumbent, the Honorable Apex Court has laid down detailed guideline in the case of Avtar Singh reported in so-and-so. The case has been relied upon in a recent judgment, so-and-so, my lord. Both the judgment I have placed before your lordship, and I'll just rely upon that, my lord. Before issuing the impugn notice of termination, the matter was considered by the authorities in the note sheet annex in the affidavit in opposition, from which it would appear that the authorities did not consider the guideline laid down by the Apex Court in Avtar Singh.
Where is this note sheet?
I've read, my lord, that they have only considered that only 452.
No, where that affidavit in opposition?
89, my lord, I've read, my lord, just. 89, 90, I read the entire thing, my lord.
Oh, 89, 90.
Yes, madam.
You have the records.
Records may not be necessary, lordship.
I want to see the note sheet. One allegation is there. That Avtar Singh's case was not considered when the termination order was passed.
No, lordship, here, lordship, we are not challenging his acquittal, lordship. We are not filing this case for appeal against acquitted. What is
No. That we
petition
know.
is only for
that
setting
we
aside.
That we understand. That we understand that you are not challenging acquittal.
Yes, Lordship. Criminal case is
Only
only
case
a
is that
background.
since he was having a criminal case that was suppressed,
Lordship,
you have
that
issued
is,
the
Lordship
termination.
may
So
kindly see.
anyway, we'll see.
So Avtar Singh has, it's a full bench decision, my lord. It has taken into consideration, I'll place before your lordship, number of earlier judgment, my lord. How this kind of things to be handled. If so factor the fact that a criminal case, as you, in my case is different, my lord. I did not have knowledge. Even in some cases, my lord, they were convicted or they were admittedly having knowledge, my lord. If they have taken bail, they must have knowledge, my lord. In my case, it is different. In that case also, my lord, if that incumbent was young and it was a petty offense, my lord, court has repeatedly said that that cannot be only a ground of terminating from a government service, my lord. So these are the things I'll place before lordship, my lord. Then number C, my lord. Or I place the judgment before lordship, my lord. Number 2. My lord. Avtar Singh is there, my lord, before your lordship. Two 2016 8 SCC, my lord.
Yes.
Para 20 other your lordship may scheme, my lord. Para 27.
Para?
27, my lord. 27 onward, I'll read, my lord.
Yes.
Well, para 27, this court has taken down all the judgment passed by earlier, my lord. This is a 3-bench judgment court, my lord. Earlier judgments were division bench, my lord. When we take stock of the aforesaid decision of this court, in a nutshell, it emerges that, my lord, I am not reading all the judgment, just the relevant but for my case, my lord. 27, 4 lordship kindly see, my lord. In Sandeep Kumar, this court, in the backdrop of fact of the case, held that the offense suppressed was committed under section 325-34 at a time when the incumbent was only 20 years of age, held that young people are to be dealt with leniently. They should not be deprived of appointment as suppression did not relate to involvement in a serious case. 27.5, my lord, in Ram Kumar, this court considered a case when pending criminal case under section 323, 24, 323 and 504 in which subsequently acquittal had been recorded. No overt act was attributed by sole witness in so-and-so. And moreover, government instruction dated so-and-so requiring authority to consider suitability as such was not complied with, denying back wages to the incumbent. His appointment was ordered. Then 27.7 also, action was taken when the employee was not on probation. He had been confirmed in service and he was holding the civil post.
That is not relevant.
That is not relevant, my lord. So the various judgment now, para 29, the ratio has been laid down, my lord. What the court should do, my lord. 29, my lord. The verification of antecedent is necessary to find out the fitness of incumbent in the process of a declarant is found to be good moral character on due verification of antecedent merely by suppression of involvement in trivial offences which was not pending on the date of filing attestation form, whether he may be deprived of employment. There may be case of involving moral turpitude, serious offense in which employee has been acquitted, but due to technical reason or giving benefit of doubt, there may be situation when person has been convicted of an offense before filing verification form or a case is pending or information regarding it has been suppressed, whether employer should wait till outcome of the pending criminal case to take decision, or in case when an action has been initiated, there is already conclusion of criminal case resulting in conviction or acquittal as the case may be. The situation may arise for consideration for various aspects of the case where disclosure has been made truthfully of required information. Then also authority is required to consider and verify fitness for appointment. Similarly, in case of separation also, this is important, my lord, In case of separation also, if in the process of verification of information, certain information comes to notice, that also employer is required to take decision considering various aspects before holding incumbent as unfit. If on verification of the antecedent a person is found fit, at the same time authority has to consider effect of separation of a fact which he has tried for trivial offenses, which does not render him unfit. What importance to be attached to such non-disclosure? Full stop. Can there be a single yardstick to deal with all kinds of cases? The employer is given discretion to terminate or otherwise to condone the omission. Even otherwise, once employer has the power to take a decision when at the time of filing verification from declarant has already been convicted, acquitted in such case, it becomes obvious that all the facts and attending circumstances, including impact of suppression or false information, are taken into consideration while adjudging suitability of an incumbent for a service in question. In case employer comes to the conclusion that the separation is immaterial, and even if facts would have been disclosed, it would not have adversely affected fitness of an incumbent for reasons to be recorded, it has power to condone the lapse. However, while doing so, the employer has to act prudently on due consideration of nature of post and duties to be rendered. For higher official, higher post, standard has to be very high, and even slightest of false information or separation may by itself render a person unsuitable for the post. However, same standard cannot be applied to each and every post. In concluded criminal cases, it has to be seen what has been suppressed is material fact and would have rendered an incumbent unfit for appointment. An employer would be justified if in not appointing, or if appointed, to terminate service of such incumbent on due consideration of various aspects. Even if disclosure has been made truthfully, the employer has the right to consider fitness, and while doing so, effect of conviction and background facts of the case, nature of offense, etc. have to be considered. Even if acquittal has been made, employer may consider nature of offense, whether acquittal is honorable or giving benefit of doubt on technical reasons, and decline to appoint a person who is unfit or dubious characters. In case employer comes to a conclusion on that conviction or ground of acquittal in criminal case would not affect the fitness of the employment, the incumbent may be appointed or continued in service. Coming to the question as to whether the employee on probation can be discharged, refused employment though he has been acquitted in the criminal charges, if his case was not pending when from was filed. In such matters, employer is bound to consider grounds of acquittal and various other aspects, overall conduct of the employee, including his acquisitions, which have been leveled if on verification or antecedents are otherwise are not found good, and in number of cases incumbent is involved, then the notwithstanding acquittal in the case, it would be open to the employer to form his opinion as to the fitness on the basis of the materials on record. In case offense is petty in nature and committed at young age, such as stealing a bread or shouting a slogan, or such as or is such which does not involve moral turpitude, cheating and misappropriation, etc., otherwise not a serious or heinous offense, the accused has been acquitted in such a case when verification form is filled. Employer may ignore such separation or so. So last part is very much applicable in my case, my lord. No doubt about it that once verification form requires certain information to be furnished, declarant is duty bound to furnish it correctly, and any separation of material fact and submitting false information may by itself lead to termination of service and cancellation of candidature in an appropriate case. However, in a criminal case, incumbent has not been acquitted and case is pending trial, employer may well be justified in not appointing such an incumbent or in terminating service, as conviction ultimately may render him unsuitable for the job. So and so. This is not relevant, my lord. 33. The fraud and misrepresentation, vicious transaction, and in case employment has been obtained on the basis of forged documents, as observed in so and so, it has been observed in the reference order that if an appointment was procured fraudulently, the incumbent may be terminated without holding an inquiry. However, we add a rider that in case employees is confirmed holding a civil post and has protection under 311(2), due inquiry has to be held. So this is not also applicable. 34. No doubt there is no doubt about it that verification of character and antecedent is one of the important criteria to assess suitability and is open to the employer to adjust antecedents of the employment. But ultimate action should be based on objective criteria on due consideration of all relevant aspects. Now, as I submitted before, Lordship, my lord, the fundamental of the foundation of the order, no such consideration has been made. The authorship has not been considered, my lord. Now, Lordship, kindly see, separation of material information presupposes that what is suppressed that matters, and every technical entry will not every technical entry will matter. The employer has to act on due consideration of rules and instruction, if any, in exercise of power in order to cancel candidature or for terminating the services of the employee. Though a person who has suppressed the material information cannot claim unfettered right for application, appointment, or continuity in service, but the right not to be dealt with arbitrarily and exercise of power has to be in reasonable manner with objectivity, having due regard to the facts of the cases. 36 is not relevant, my lord. 37, the McCarthyian is antithesis to constitutional goal. Chance of reformation has to be afforded to young offenders in suitable cases. Interplay of reformative theory cannot be ruled out in toto, nor can be generally applied, but is one of the factors to be taken into consideration while exercising the power for cancellation of candidature or discharging employee from service. Now, considering everything, the court has now issued the final guideline, madam. I am concluding, madam. This is only one page, madam. We have noticed various decisions and tried to explain to reconcile them as far as possible.
From?
Page 38, para 38, madam. Last part, considering everything, madam. Now, guideline has been laid down.
38.
38, madam. We have noticed various decisions and tried to explain and reconcile them as far as possible. In view of the aforesaid discussion, we summarize our conclusion thus. Information given to the employer by a candidate as to conviction, acquittal, or arrest or pendency of criminal case, whether before or after it entering into service, must be true, and there should be no separation of facts or separation or false mention of required information. 38.2, my lord. While passing order of termination of services or cancellation of candidature for giving false information, the employer may take notice of special circumstances of the case, if any, while giving such information. 38.3. The employer shall take into consideration the government orders, instruction, rules applicable to the employee at the time of taking decision. 38.4. In case there is separation of or false information or involvement in a criminal case where conviction or acquittal has already been recorded before filing of the application or verification form, and such fact later comes to knowledge of employer, any of the following recourses appropriate to the case may be adopted. 34.4.1. In case of trivial nature in which conviction has been recorded, such as shouting slogan at so and so, my lord, which is disclosed, would not have been rendered an incumbent unfit for the post in question. The employer may, in question, ignore such separation of fact and false information by condoning the lapse. Where the conviction has been recorded in case which is not trivial in nature employer may cancel candidature or terminate service of the employee. If acquittal had already been recorded in case involving moral turpitude or offense of heinous and serious nature on technical ground, and it is not a case of clean acquittal or benefit of reasonable doubt has been given, the employer may consider all relevant facts available to the antecedent and may take appropriate action as to continuation of the employee. Then 38.5, 6, 7 not relevant, 38.8 is important, my lord. If a criminal case was pending but not to the candidate at the time of filing his form, still it can have an adverse effect, and the appointing authority would take decision after considering the seriousness of the crime. 38.9 and 10 I'm not reading. 38.11 I'm reading, my lord. Before a person is held guilty of separation, vary, or suggestio falsi, knowledge of the facts must be attributed to him. So, my lord, Avtar Singh has clearly laid down that whenever you take a decision considering all aspects of the matter, the nature of the crime, the age of the accused person, whether he has been acquitted, if acquitted, my lord, whether he was acquitted free from all reasonable doubt or on technical ground. All these factors, the authorities have to take a decision, and that to take a decision what to do with me, my lord. Nothing of that sort from the affidavit also, nothing will appear that nothing that exercise was done, my lord. And the page 18 and I have read, my lord, that only takes into consideration, my lord, 452. 452 was not there at any point of time, my lord. Trespass with a plan to do something wrong, my lord, that was a serious charge, my lord. That was not in the charge sheet, and that was not considered by the court. So 452 was hovering in their mind, and they have taken a decision without considering Avtar Singh, my lord. Now, another decision I placed with your lordship, just reiterating Avtar Singh. I'm not reading that, my lord, fully. That decision is placed 2022 SCC online, my lord. Pawan Kumar versus Union of India.
Yes.
And here, one factual part I'm placing, my lord. This is laid down in paragraph, my lord, you can see 11, 12 onward, my lord. Avtar Singh has been reconsidered again. Paragraph 14 may be read, my lord, on facts. Supreme Court, my lord, was taking the matter, my lord. They asked the authorities that you reconsider the matter on the basis of Avtar Singh, because Avtar Singh was not considered the guideline. Has your lordship got paragraph 14, my lord? At one stage, after the matter being heard, detailed order was passed by this court on so-and-so, after taking note of the judgment of Avtar Singh, directed the employer to review his decision in the light of the decision of this court. In compliance thereof, the review order has been passed on so-and-so, confirming its earlier decision on discharge so-and-so, so-and-so. The bare perusal of the review order dated so-and-so itself declared that the authority has not applied its mind, and just after reproduction of the facts, confirmed the order of discharge so-and-so matter. So therefore, my lord, in this view of the matter, finally, Supreme Court has set aside the matter, my lord. Set aside the punishment matter.
Yes.
So in this case, my lord, entire thing, my lord, if your lordship so consider, my lord, as for the judgment of the Avtar Singh, the authorities should consider Avtar Singh and then take a decision. That exercise has not been done, my lord. Supreme Court also did, my lord. During the pendency of the case, this exercise was done. If they come up with an adverse order, the applicant can come again, my lord. And if they come with a favorable order, the matter. Now, I come to the third argument and third argument, my lord. The petitioner was duly selected and appointed to the post of junior engineer and was on probation for 2 years when he was given the notice of termination on allegation of separation of facts regarding his prosecution in a criminal case. The allegation was stigmatic and it was not a case of termination simpliciter. Therefore, it invokes the protection of Article 311 of the Constitution of India, and his service could not have been terminated under the provision of CCS Temporary Service Rule 1965 without holding a regular inquiry under the provisions of CCA rule. Now, I have relied on a judgment, my lord, before your lordship, my lord, 2023 SEC, my lord, VP Ahuja versus State of Punjab. It basically says that even at the time of probation, my lord, if termination is ordered, that has to comply Article 311 if that is on the basis of stigma, my lord. Only 2 paragraphs, 8 and 9, my lord. Para 1 and 2, the facts, my lord, his service was terminated by the order without following the procedure. 8 and 9, my lord. The affidavit filed by the parties before the High Court, as also in this court, indicate the background in which the order of terminating the service of the applicant came to be passed. Such an order, which on the face of it is stigmatic, could not have been passed without holding a regular inquiry and giving an opportunity of hearing to the applicant. The entire case law with respect of a probationer was reviewed by this case in the recent decision of Dipti Prakash Banerjee versus so and so. This decision fully covers the instant case as well, particularly in this case, the order of impugn is stigmatic on the face of it. For reasons noted above, the termination was quashed. So I was on probation. There was a stigmatic allegation against me that I have suppressed material fact. Therefore, now for a moment, my lord lordship may kindly take up that CCS temporary service rules, my lord. They have terminated me under that provision, my lord. I have a copy, lordship. CCA rules.
CCA rules.
CCS temporary service rules 2065. That may be their matter. I have a copy, your lordship.
You have a spare copy?
Spare copy. The definition, lordship, kindly see second page, my lord. Temporary service. Temporary service means service of a temporary government servant in a temporary post or officiating service in a permanent post under the government of Assam. So only in that case, only this rule is applicable. And my case is that I was duly selected, I was put on probation, against sanction vacancy, my lord. So temporary, I was not a temporary service, my lord. I was not in temporary service. They have applied this rule because there is a shortcut. Just give a notice 1 month termination without giving any reason. You can terminate.
You're terminated
Under this CCS temporary service rules 1965. The order of termination, my lord. $49, my lord. 'Judgment get available.
Yes.
So, my lord, I summarize my submission, my lord. First thing, my lord, I have shown on record that, my lord, I had no knowledge about this case. Second thing is that, my lord, the case which was registered was a very trivial in nature. It was an altercation, my lord. The main accused person, the woman who made allegation against me in the FIR, my lord, they have categorically said that I was not at all involved in any beating or slang. Only at the behest of some villagers they have filed the FIR, my lord. That is there in the judgment. Though in the last line it is mentioned that it is in benefit of doubt. If your lordship reads the judgment, my lord, there was no evidence against us, my lord. On the contrary, all the prosecution witnesses were saying that I did not do the offense, nor my family members, nor me, my lord. It was only on the instigation of the villagers, my lord. My lord, this is one. Assuming for the timing that they hold that I have suppressed the facts, my lord. Then also, my lord, that after thing says that, my lord, various factors is to be considered. If it is a trivial case, I was very young, which is applicable in my case, my lord. Then, my lord, those things are not taken on record, my lord, not considered, my lord. And number 4 is that CCS rule and that stigmatic order, my lord, that has been passed, that I have suppressed material fact, my lord. That in that case, a regular inquiry was necessary, my lord. So these are the downs I have agitated in this case now.
That is a list of the case and sequence of events on behalf of the respondent, lordship. Lordship, regarding the first point, lordship, that no knowledge of pendency of the case. So lordship may see that the incident happened in the year 2014, 13/7/2014. FIR was lodged on 15/7/2014. Lordship may turn my note, 5th page of my written submission, lordship. There I have stated the sequence of events. Second.
Thank you.
That sequence of events and annexes, 5th page. Lordship, got it?
Last page.
No, not last page. The
third page.
5th page. 5th, not 5th. Third page, third page, lordship. Sequence of event. 13/7/14, incident happened between the petitioner and his family with his neighbor. 15/7/14, FIR lodged against the petitioner and his family. 26/4/16, petitioner was appointed as junior engineer civil in GR grade and will be on probation for a period of 2 years. 18/6/16, regarding that and character and antecedent verification, we came to know that a case is pending against the petitioner, lordship. unless this cleared lordship, antecedent and character verification, they were not regularized. Before regularized, they have to clear this antecedent and character verification. That lordship, then we came to know lordship that a case is pending. On 1/10/16 lordship, the learned CGM acquitted the petitioner and his family on benefit and doubt from the charges. Lordship, here lordship already had, my learned senior had read the paragraph of the judgment. Lordship, I am quoting paragraph 4, 6 and 7 of the judgment in my note also. Lordship had already gone through what this paragraph 4, 6 and 7 of the judgment, whereby the petitioner was acquitted on benefit and doubt. Lordship, this 4, 6 and 7 of the paragraph was lordship. The summon has been issued against the accused persons for trial. Accused has appeared before the Honorable Court and copies of all the relevant documents of the case furnished to them under Section 207 of CRPC, and charges have been explained to them, and when the accused has denied and went for trial. FIR is exhibited as Exhibit K1. Remaining documents are exhibited by the prosecution and same were accepted by so-and-so learned counsel of the accused under Section so-and-so. Statement of accused persons were recorded under Section 313 of CRPC. So this shows that they were appeared, lordship, they got their bail, and all the documents were submitted to them. Even with not admitting and assuming that, lordship, that he has no knowledge about that, but as from their own case is that, lordship, he came to know about the incident in the year July 2016. But thereafter also, he had never tried to ever intimate the authorities that at the time of his appointment, a criminal case was pending, lordship. So the submission that he was unaware, that is not there, lordship. And also he was acquitted, lordship. It's a benefit of doubt, lordship. Secondly, lordship, Avtar Singh, lordship. Yes, Avtar Singh has given the authority the discretion to consider the case. But lordship, here other judgments are there, lordship. I am submitting one of such, lordship. This is by Lord Justice M.K. Shah. This is 2021 10 SCC. 2000. Yes, lordship. Lordship, here the same situation has arisen, and I'm reading the relevant portion of paragraph 14, lordship.
1 minute.
21 10 SCC, what page?
10 SCC 136. Same, almost same situation. Non-disclosure of pending criminal case in application appointment, so and so, lordship.
Just
yes.
yes.
Paragraph 14, 14, 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. the issue or question may be considered from another angle, from the employer's point of view. The question is not about whether an employee was involved in a dispute of trivial nature and whether he has been subsequently acquitted or not. The question is about the credibility and the trustworthiness of such an employee who at the initial stage of the employment, that is while submitting the declaration or verification and or applying for a post, made false declaration and or not disclosing and or suppressing material facts of having involved in a criminal case. If the correct fact would have been disclosed, the employer might not have appointed him. Then the question is of trust. Therefore, in such a situation where the employer feels that an employee who at the initial stage itself has made a false statement and or not disclosed the material fact and or suppress the material fact, and therefore he cannot be continued in service because such an employee cannot be relied upon even in future. The employer cannot be forced to continue such an employee. The choice or option whether he continue or not to continue such an employee always must be given to the employer. At the cost of repetition, it is observed and as observed herein above in catena of decision, such an employee cannot claim the appointment and or continue to be in service as a matter of right. In view of the appropriate facts and circumstances of the case, both the learned division bench as well as the learned single bench have clearly erred in quashing and setting aside the order of termination, terminating the services of the respondent on the ground of having obtained an appointment by suppressing material facts and filing a false declaration. The order of reinstatement is wholly untenable and unjustified. In view of the above and for the reasons stated above, present appeal succeed. Here, the respondent's authorities have filed the appeal. So that is allowed, Lordship.
The show cause notice was issued.
Here also, Lordship, that is their third ground. I'm coming to that, Lordship.
No. Here also, in this case.
Yes.
Show cause was issued.
In which?
This case
Lordship.
which you are relying on.
Yes, Lordship.
A show cause notice was issued.
Yes, Lordship.
Correct?
Yes.
You read para 2.3.
But here that is not necessary because he was a temporary employee. The rule governed in my case.
He was a probationer.
Yes, Lordship.
So read para 2.3.
Having found that the respondent employee deliberately suppressed the fact of conviction and penalty not only at the time of applying for the post, but also on 14/4/15, whereby he submitted the declaration during document verification that neither criminal case is pending against him, nor he has suffered any conviction by any court of law in any criminal case, and finding concealment of fact of criminal case. Appellant issued a show-cause notice dated 31/8/2015 to the respondent employee and granted him an opportunity of being heard on 15/3/16, and having found that in view of suppression of material fact of not disclosing his conviction of the competent court, respondent employee shall not be continued in service, and therefore by the order that is so and so, appellant terminated the service of the respondent employee.
Show cause was issued here.
Here, Lordship, that is not necessary under rule temporary service rule. I am now coming to that.
No, here also in this particular case, the employer was on probation.
What has to take care of that, whether that is punitive in nature or termination simpliciter. That is the main thing, Lordship. Here in our case also, Lordship, during which is a regular practice, during that period we came to know about that this is cannot be said to be that is only for him. This is a general practice, and during that practice, Lordship, we came to know, and thereafter we had terminated him. And Lordship may kindly now come to my affidavit, Lordship.
Now, how do you say that this rule is applicable?
Lordship, because the petitioner was a temporary employee. We have to go by the order of appointment, Lordship, offer of appointment. Lordship, my affidavit, Lordship, the page 100, Lordship. Page 100. So there is judgment, Lordship, that one has to go by the order of appointment or the advertisement, Lordship. This is the order of appointment, Lordship. Page 100.
Affidavit in reply.
Now opposition. Page 100. Constitution page is 100.
Mine is affidavit in reply.
No, it will be 96, my lord.
Page?
Page 96, my lord. Clearly mentioned that consequent upon its selection, my lord.
Yes.
Lordship.
Appointment.
Yes, Lordship. This is the appointment order and offer of appointment, and he had accepted this. The conditions of the appointment is very much clear here. So the relevant portion is from next page, Lordship. Terms and condition of appointment are as follows. Next page, Lordship.
Yes.
You will be on probation for a period of 2 years from the date of appointment. During the period of probation, you will be required to undergo such training and take such departmental tests as the government may prescribe. On completion of the period of probation, your suitability for continued appointment as so-and-so will be assessed by the competent authority. So only after completion of probation, his suitability will be assessed. The period of your probation may be extended at the discretion of the competent authority based on your performance. Failure to complete the period of probation or extended probation to the satisfaction of the competent authority and to pass the prescribed test will render you liable to be discharged from service or to reversion to your substantive post if any under the central or state government in which you may be retaining lien. B. Appointment is subject to termination by the appointing authority at any time during the period of probation by giving 1 month's notice by either side, that is the appointee and the appointing authority, without assigning any reason. The appointing authority, however, reserves the right of terminating the services of the appointee forthwith or before the expiry of the stipulated period of notice by making payment to you a sum of equivalent to the pay and allowance for a period of notice or the unexpired period thereof. This provision of paying the sum equivalent to notice period or unexpired portion thereof will not be available to the appointee. This is in terms of Rule 5 of Temporary Service Rule. You are required to furnish declaration in the enclosed format regarding your marital status so-and-so. Then next page, Lordship. Clause 5. Yes. If any declaration given or information furnished by you is found to be false, or if you are found to have willfully suppressed any material information, your services are liable to be terminated without giving reasons under Rule 5 of CCS Temporary Service Rule 1965 and CCS Conduct Rule 1964. So this is very much clear from his offer of appointment that he will be governed by Temporary Service Rule, Rule 1965 during his probation lot. And that offer of appointment, he was aware that this is the service condition. And on the basis of that, Lordship, that notice is required to give 1 month notice either side, Lordship. Either he may leave with giving by 1 month notice, and we can terminate him by giving 1 month notice, Lordship. That is followed, Lordship.
Yes.
That is followed, Lordship. So there, the authority.
What is that note sheet that you have annexed?
This is only an official communication, Lordship. Whether 452 is there or not, they want to know. But the authorities have acted as per rule, Lordship. Temporary service rule is there. That authority conditions are very much there.
Yes.
So that is their, Lordship. What is their prayer in the writ petition is, Lordship, to set
No,
aside-
but in when you were considering his matter, you were always under the impression that that the section 452.
That is their, my learned senior had given way to that, Lordship, but this has nothing to do. This is only a communication, official communication, Lordship. But whether 452 is there or not, Lordship, he is not entitled to retain in service by for giving false information. The recent judgment I have just given now, Lordship, my Lord Justice M.K. Shah, that is shown that it is the authority's discretion, Lordship. Even in Avtar Singh also given the discretion to the authority. Yes, Lordship, if we have not given him the no notice was issued, if he is entitled for a regular hearing, if he is a permanent employee. As he is a temporary employee, he is governed by temporary service rule, as I have already stated. And as per temporary service rule 5, 1 month notice we had given. And after that notice, he had came here and the petition is filed, so he is still continuing in service. So that is the present position. So there is no violation of any rule because he is not a regular employee. His offer of appointment is very much clear. Had we not given him 1 month notice also, then, and if he is a regular employer, had not we given him a regular hearing, possibly that case, we have to give him a so-cause notice, etc. at their law. But here our offer of appointment is very much clear and he have knowledge about that logic. Even he can terminate the services by himself by giving a 1 month notice. If we terminate him before 1 month, we have to give him 1 month's payment. That is the case lordship here. Unless he is confirmed lordship, his services as probation period may be extended also if we are not satisfied with his performances. That is there. Unless he is completed or he is satisfied lordship, his services cannot be regularized lordship. And till then, he is governed by this temporary service rule lordship. And this is the very much clear from his offer of appointment. This termination is, as per law lordship, there is no violation of anything lordship. After seeing and all the rule has given the discretion to the authorities, here we have considered his cases. And he may be acquitted, but at the time of filing of his application form, a case was pending against him. And he was acquitted on benefit of doubt. Whatever be there in the criminal case, in the latest case. But at that time, a case was pending. 452 was initially there, lordship. Only at the search level, it was. That is why we want to know, because at the time of filing of the FI, 452 was there. So here, I have already stated, we are not to see that criminal case because we are not on a criminal case. Whether the justified or not, that is has to see the termination. If there is no violation of any rules, so possibly lordship, I may be wrong lordship, but possibly the discretion of the honorable court, if there is any violation or there is any biasness or no opportunity was given, that has to be seen by the honorable court. Here, whatever is governed, he is not a regular employee, so regular service, regular hearing is not, will not come to play lordship. That 1 month notice that the CCS service rule that is governed and offer of appointment is very much clear. After knowing everything, he has accepted that. He may also leave the job by giving 1 month notice. That 3A, B, and this 5 is very much clear lordship. And that is the rule, and we have followed accordingly. The termination order was issued. If those are the main 3 points, lordship. Because writ petition was filed, setting aside and quashing that the TCS temporary service rule is not employed. But our case is that as he is a professional, his services are never regularized, so he is governed by that rule, and we have followed that. And those we have already stated in my affidavit also. I have shown the documents, lordship, that my paragraphs are there, lordship. Paragraph 15, we have stated, lordship may kindly take up this page 53, possibly page 53. Para 15.
Yes.
More so, 5th line, lordship. More so, according to the petitioner, he had came to know about the criminal case in the month of July 2017. The petitioner was appointed in grave as junior engineer civil on 26 April 2016 and posted so and so. But thereafter also, the petitioner did not intimate about pendency of the criminal case to the respondent authorities. The authorities could come to know about the case only at the time of verification as per service rule. Suppression of material information and making false statement has a clear bearing on the character and antecedent of the petitioner. Therefore, the action taken by the appointing authority to terminate the service of the petitioner is in order as per the Government of India's decision number so and so and Rule 5.1 of CCS DS rule. Government of India's decision number 2 subpara para 2 below Rule 11 of CCS control classification control and appeal rule 1965 inter alia states that whenever it is found that a government servant who was not qualified or eligible in terms of the recruitment rule, etc., for initial recruitment in service or had furnished false information or produced false certificate in order to secure appointment, he should not be retained in service. If he is a probationer or a temporary government servant, he should be discharged or his services should be terminated. If he has become permanent government servant, an inquiry as prescribed in Rule 14 of CCS, CCA Rule 1965 may be held. As such, the petitioner is entitled to so and so. And then I have also quoted the relevant portion from the offer of appointment law. Dear Lordship, I just want to place one more judgment from our High Court. Here also, Lordship, this is a CRPF employee who service who was on probation for more than 14 years, but then his services was terminated under Central CCS sub rule 1 of 5, the same rule, Lordship. He had 14 years of service, but his services was also not confirmed and he was on probation. Although it's 14 years, then also Honorable Court has held that that is not punitive in nature, and so his services was held that that the order of discharge was not punitive. Here also the order of discharge was not punitive. We came to know about this only. Lordship.
Which para you are?
Yes, Lordship, paragraph 31. The only difference is that here he had submitted a false certificate. Considering the above legal principle as well as the fact of the present case, it is clear that the employer in the present case, in their regular course of verification, came to know that the certificate produced by the petitioner was fake on the basis of intimation given by the Education Board, according to the petitioner who issued the certificate. After receiving such information, employer decided not to go for further inquiry, so and so. Therefore, in the considered opinion of this court, then here same thing, Lordship. We on fake certificate was issued here. Non-disclosure of pendency of the criminal code. In the aforesaid view of the matter, it is considered opinion of this court that disclosure of the fact in the affidavit and as discussed herein above cannot make the order of discharge punitive, and accordingly it cannot be held that the petitioner is entitled for so and so. So if it is termination solicitor, then termination cannot be made him eligible unless it is punitive in nature, Lord. This is what held. Here 14 years. He was on probation, but his services terminated under CCS temporary service rule. So that is the rule applicable to the petitioner as per the respondent. And after giving 1 month notice, we have taken the steps. He is not entitled for any regular inquiry that is paid in the petition. And other factor, Lordship I have already shown that he was aware, and when he came to know about that also, he had not intimated about the same. And after seeing, and all the recent judgments also given the authorities the discretionary power whether they will retain the person or not to. These are the 3 points that was raised. It might happen.
Yes.
I'll take 2 minutes, madam. Learned friend is saying that even after having knowledge about this, I have not informed my. Wherefrom my learned friend is saying this thing, I am not getting it, madam. When I came to know, I have taken bail. I have sworn an affidavit. Authorities are very much aware. They are making inquiry, madam. Where is the question of separation, madam? I have sworn an affidavit also to the action. Before taking bail, madam. Before taking bail, madam, I didn't know. Neither my family member knew, madam. That is my specific case, madam. After that, I have sworn an affidavit. Before that, I had no knowledge.
Where
So
is
therefore,
that affidavit?
madam.
Where is that affidavit?
Affidavit, madam. I have read. Again, I'm placing this for loss, madam. Uh, 41, my lord, page 41. My lord, that paragraph number 2, my lord, that I, Sri Dhananjay Kumar Yadav, do hereby declare that I have been informed by my father that on so and so, that a case on July 2016, that a case number so and so, under section so and so in Khosi PS district so and I was co-accused along with my father. After receiving the same information, I took leave from the job and came to home and appeared in the said pending criminal case between so and was released on bail on the same day. I, Sri Dhananjay Kumar Yadav, do here declare that the said case has been disposed of in so and the deponent was acquitted so. I, Dhananjay Kumar Yadav, do hereby declare that prior to July 2000, the deponent had no knowledge about the pending criminal case. So all these things, my lord. Only when the authorities informed me, my lord, they came to know, they informed me, then only I have gone and taken bail, my lord. I was really surprised. I didn't know about this, my lord. And it was a petty case, so bail was given, and within 2 months, judgment was given. This is my lord. Now, Lordship may kindly see, my lord, only one thing, why they have given me the notice of termination. That their allegation is that I suppressed the fact that I had knowledge about this case. Still, I have given a declaration that there is no criminal case pending against me. That declaration, Lordship may kindly see for a moment, my lord. They have enclosed it. Page 78, my lord. My lord, 12(1)(a), my lord. Have you ever been arrested? No. It is correct, my lord. I was never arrested. Have you ever been prosecuted? No. Hindi, it is written nahi, my lord. This is the wrong declaration, my lord. And this was given on, my lord. Next page, your lordship will get the date, my lord. 8/9/2015. I have come to know regarding police verification period, my lord, that a criminal case was pending against me. That time it was pending. In 2016, July 2016, then I came and took bail, my lord. So where I have suppressed, my lord, that learned friend is saying that even after knowledge, my lord, I have sworn an affidavit to that extent. And authorities were time and again verifying the fact whether 452 was there or not. So it was very much in our knowledge and their knowledge also after this, my lord. Not at the time when I signed the verification, my lord. And what is the case, my lord? Observing is a full bench judgment, my lord. That was the judgment which has been relied by facts I don't know whether he was convicted, what was the age, what are the attending circumstances. But observing says one thing, my lord. Employer is the final authority to take a decision. But while taking a decision, the employer has to consider the entire thing, my lord. That has not been done here, admittedly, my lord. It is not their case that they considered my case under obstruction, my lord. That is not their case, my lord. They possibly can't say, my lord, obstruction was irrelevant for us, my lord. Even in that Supreme Court judgment, my lord, during the pendency of the case, it was sent for consideration under obstruction. And it has come back, my lord.
Okay. But Mr.
B. Chakravarti.
D. Chakravarti, Leonard Council. Also had MS Nisham. Leonard CGC for the respondents. Hearing concluded. Judgment of the.
Obliged.
They have appointed one PWD candidate. And another was brought in, another PW candidate was brought in on the ground that he belongs to SC category. Double reservation. Access reservation. Reservation is only in one quota. If someone is SC, he is entitled to SC. If someone is in PWD, he is in PW. He will not be considered against any other reserved quota, even if he belongs to SC category. In caste, he belongs to SC. But he is seeking employment in the category of PW. He will be considered in the category of PW. Once a candidate is selected against that category, PWD, it cannot be considered that he also belongs to SC, therefore he should be fit into the SC category. No. That amounts to double reservation. As PWD as well as SC. That cannot be done. Decisions of the apex court, this federal court, these are there. My grievance is, I have been left out from the select list because of this access reservation. Another PWD candidate brought in and shown against the reserve court. That is my simple case. Even without going to the other disputed positions regarding the number of posts they have kept reserved for the candidates to be selected against those categories. Here, even against that post, 12 posts, SC, it should actually they have shown 12, although my calculation 7%, 22 posts minimum. How they have made this? 22 posts it should have been against those posts. So here 320 posts. Out of 320, 7% goes to 22 posts. They have shown 12. Even against that 12 posts, while they have made the selection, they have committed the mistake that they have brought in 2 PWD candidates. One PWD candidate was already posted against the SC category. That's okay if that a particular post in that category, SC category, is already identified as a post which is suitable to be occupied by a PWD candidate. Well, Lordship is aware that they will have to identify the particular post for the particular category of disability, so that he can be fit in that post, because he will be able to discharge the duties there in that post. Otherwise, no. Merely because a person is PWD, he cannot be just brought in and appointed against a particular post unless it is decided and identified that this post should be filled up by a person of visually impaired or by an orthopedic disability. Like this. There has to be the identification of the post for the particular category of disability. Now, here, they have brought in one, they have not identified which category of disability, but they have posted one. Here, they have shown one. This is, my lord, the ultimate select list result sheet. This was done by showing the open categories of the persons. Their reserved category also shown. Here, Lordship will kindly see SC category selection, Lordship will kindly see. I will identify the serial numbers against which selections have been made. Kindly come to page 42. Serial number 8990. These 2 posts, SC candidate, and then Lordship will kindly skip over that page.
This is open category, isn't it?
Open category. Open category in the sense SC simpliciter.
Oh.
Those who are SC without any physical disability. Those who have applied under the quota, SC quota. SC simpliciter. Such persons are selected, and they said that there are such 12 posts for them against SC quota. Under this advertisement, they say 12 posts. And How many persons they have selected? That is what I am coming, my lord. Page 42, Lordship will see these two persons, SC at page 42, serial 89, 90. Then kindly come to next page 43. Serial number 116, his SC. Then again 120, SC. These are reserved. They have shown as reserved column, right hand column extreme, reserved. SC. And then kindly see 132, SC, reserved. Then 141, SC, reserved. 144, SC, reserved. Then 150, SC, reserved. These 8 persons already here. Now, kindly come to the next page 46. 46. Females are also here. We will skip that female mallet. Here, female lordship will see serial 236. This is SC female. SC female, serial 247. Serial 272, SC female, reserved. No difficulty, because as reserved category female, they will get that, they will be fit in there. And then 288, page 47, female. These 4 candidates are there. This is female reserve. Now, kindly see page 48. Here, serial 317. He is SC, PWD, hearing impaired, reserved quota. He is SC reserved. He is SC, so he is brought in there. Again, 218, 318 serial, 318 position they have shown, 318. Suman Das, SC, visually impaired, reserved. Two PWD candidates have been brought in against this 12 post. Whereas both are brought in on the ground they belong to SC category. This consideration is wrong. SC category is not applicable to them. They are only physically handicapped category. Against the post available for SC category, reserved category, if one vacancy is identified for a particular category of PWD candidate, then he can be, because he is a PWD candidate and a particular suitable post is identified in the SC category, he can be brought in and appointed there. But not because he is SC as well as he is, the physically handicapped. Not at any rate too. Not at any rate too. They are to be distributed in all the groups. SC, ST, SC, IC, open category, in all the categories. Therefore, my response submission is this was excess reservation, wrong selection of the candidates belonging to PW. If one is out, I come in. Let's will kindly see here, page 43. This candidate at position 8. He is at page 43. Serial 150, position 150, Orup Das. The reserve 6. Reserve 6. His position was 127.75. His marks. I'm coming to the marks also. It is there because by an order of this honorable court, they were asked to furnish the marks. Who secured how much in the merit? That was provided. They have published it. I have filed it in another affidavit. I'm just pointing out here. He secured 127.75. This person. And if he is there, he is entitled to. If one goes out of this page 48, then I come in because I have secured 127.25. This is my mark. 127.25. That means immediately after this 150 Urubdas, my position comes. 127.25. Urubdas is 127.75. Therefore, then if one PWD is brought in, whatever his marks may be, one goes, then immediately next post I come in because I am in the merit list 120 with 127.25 marks. That is my case. That is my case. In the same reserve category, 12 posts, SC. How can they bring in 2 PWD candidates? They have shown only 12. They have made selection against 12 posts, although they are to have been to SC 22 posts. What about the other 10 posts? And another issue, Lordship is aware, PWD candidates, their selection is against the cadre strength. Total cadre strength of the particular post, out of that, 4% under the law. Now, if we take it as they have shown it here, total cadre strength is 320. Obviously not, another 20 posts are there, 24 posts, which are kept separate. In this advertisement itself, they have shown 344 posts. Selection is made against 320 posts. Is it the cadre strength? If this is the cadre strength, then the 4%. But if there are other posts in that particular cadre, then the total cadre strength, out of that total cadre strength, 4%. They have shown here that out of this 320, they have taken it probably as a cadre strength. Is it so? Really? They are not specific. And they have shown 12 posts, which is not telling because 320 cadre strength, 10%, 7% SC 7%, it comes to 22 posts. SC 22 posts should have been there out of this because this is again not in cadre strength. This is vacancy wise, 7% of the vacancies. And reservation is roster according to the roster points. They have not specified how many posts in the roster vacancy is available for filling up. They simply say as per 10%, 7% SC, taking 320 posts, 7% will come to 22. There ought to have been 10 more posts, right? What they have shown here? 12. So they have shown 12 posts, SC. And out of that 12 posts, they want to fill up 2 by PWD. Was it identified and earmarked for PWD? Which category? That decision had to be taken previously, before issuing the advertisement. Otherwise, no. And why to PWD? Within one category, SC category, there are other categories, it should be distributed in all. It could not have been. Reserved category, because reason given by them is that because he belongs to SC category, therefore we have placed him in the SC category. That is not applicable. At this stage, Lordship will kindly see their affidavit, that particular. Page 72. Affidavit in opposition. $72, my lord. Yes. Paragraph 10. I am reading it. Paragraph 10. That the deponent begs to state that in the present case, the total number of posts reserved for PWD visually impaired was 4. Since there were only 3 PWD visually impaired candidates, all 3 candidates were recommended. Out of the 3 candidates, 2 candidates belong to open category. Now kindly see how they are considering it. Out of all 3 candidates, out of the 3 candidates, 2 candidates belong to open category, and accordingly, they were adjusted again to open category. Which is again wrong. There cannot be such a fixation that because they are impaired, they are visually impaired or physically handicapped from the open category, they should be only put in the open category. That is not the law. And the remaining 1 candidate belongs to scheduled caste category. Hence, the candidate was adjusted in the scheduled caste category. That means you have taken out 1 post of this scheduled caste category by a person belonging to PWD category, which you cannot do. Similarly, in case of PWD hearing impaired category, 4 candidates have been selected as per the advertisement. Out of the 4 candidates, 1 PWD hearing impaired candidate belongs to the scheduled caste category, and therefore the candidate was adjusted in the SC category. Is it permissible? No. No. They have shown the list, paragraph 11, that the deponent begs to state that under the above mentioned circumstances, the Assam Public Service Commission completed the selection process and recommended the names of 320 candidates for appointment to the post of Junior Engineer Civil in the Panchayat and Rural Development Department. In the said result, dated 31st May 2022, the following candidates were selected under the scheduled caste category. They have shown 12. This reserved category 12. And here they have shown 11, Rajiv Das, Suman Das, 11 and 12, serial number, my lord, in this chart. SC, visually impaired 1, and 1 SC, hearing impaired, reserved. So double reservation is applied here. Decision. Supreme Court says, no, you can. Is going right? Let me first place one decision of our court, where the apex court decision is relied on, and accordingly the judgment has been rendered. This is my lord, copy decision. This is the WPC 754 of 2019. Decision dated 14/2/2022. At paragraph 2, Lordship will kindly see. First, paragraph 2. Aggrieved by non-inclusion of the petitioner's name in the select list prepared for appointment in the post of veterinary officer, block veterinary officer. The instant writ petition has been filed seeking a writ of mandamus directing the respondents to appoint him against the quota reserved for the person with disabilities category candidates. Now, this was the issue. Kindly come to paragraph 6. By placing reliance on the decision of the Honorable Supreme Court rendered in case of Mohesh Gupta and others versus Yashwant Kumar Abhirwat and others reported in 2007 8 SCC 621. Mr. Chaudhary, learned senior counsel for the petitioner, has argued that law is firmly settled that further reservation amongst the disabled on the basis of caste, creed, or religion would be impermissible. According to Mr. Chaudhary, the petitioner fulfills the requisite criteria laid down in the advertisement notice, and therefore, regardless of the caste to which petitioner belongs to, the respondents ought to have considered his case as a PWD category candidate, which has not been done in this case. As such, submits Mr. Chaudhary, the present is a fit case where this court may issue a writ of mandamus directing the respondent to consider the case of the petitioner for appointment as a PWD candidate. In support of his argument, Chaudhary has also placed reliance on two other decisions of the Supreme Court rendered in the case of so-and-so, 2016 16 SCC, and the 2017 3 SCC 504. Here, he was not considered PWD as such. Other castes were brought in. So PWD gets a preference on the basis of PWD category. He is selected against. No other caste considered, creed, religion will be considered for them. They are a class by itself. PWD is a class by itself. Therefore, when you select a person against PWD category, you cannot again categorize him as SC, open category, or ST, whatever it may be, and bring in to that category. No. You can only accommodate that person against a suitable vacancy, in whatever category it may be, which is so identified to be suitable for a particular category of disabled. Therefore, my rascal submission. Here, admittedly, they have in their own statement has admitted that because they belong to SC category, they are PWD, no doubt, selected under PWD because they belong to SC category. We have brought in both of them to the SC category. This approach itself is wrong, fundamentally incorrect. Fundamentally incorrect of the reservation policy. Yes. Here, I am relying on another decision, Miller. 1995 to SCC 2745. Copy दिया सर. Here, how reservation is to be filled up, reserve post, computation, how made, percentage, all that is there. Appointment, promotion, reservation. There are 5 lordship will come, kindly come. Para 5. We see considerable force in the second contention raised by the learned counsel for the petitioners. The reservations provided under the impugned government instructions are to be operated in accordance with the roster to be maintained in each department. The roster is implemented in the form of a running account from year to year. The purpose of running account is to make sure that the scheduled caste, scheduled tribes, and backward classes get their percentage of reserve post. The concept of running account in the impugned instructions has to be so interpreted that it does not result in excessive reservation. 16% of the post are reserved for members of scheduled caste and backward classes. In a lot of 100 posts, those falling at serial numbers 1, 7, 15, 22, 30, 37, 44, 51, 58, 65, 72, 80, 87, and 91 have been reserved and earmarked in the roster for the scheduled caste. This is how this roster points have to be identified. They should mention these roster points in the advertisement. That is the correct procedure. So that subsequently there will be no confusion and there will be no excess reservation. Roster points 26 and 76 are reserved for the members of backward classes. It is thus obvious that when recruitment to a cadre starts, then 14 posts earmarked in the roster are to be filled from amongst the members of the scheduled caste. To illustrate, first post is a cadre in a cadre must go to the scheduled caste, and thereafter the said class is entitled to 7th, 15th, 22nd, and onwards up to 91st post, 100% roster. When the total number of posts in a cadre are filled by the operation of the roster, then the result envisaged by the impugned instruction is achieved. In other words, in a cadre of 100 posts, when the post earmarked in the roster for the scheduled caste and the backward classes are filled, the percentage of reservation provided for the reserved categories is achieved. We see no justification to operate the roster thereafter. Then it is complete. Thereafter, there shall be no further operation of the roster. The running account, quote unquote, is to operate only till the quota provided under the impugned instructions is reached and not thereafter. Once the prescribed percentage of post is filled, the numerical test of adequacy is satisfied, and thereafter the roster does not survive. The percentage of reservation is the desired representation of the backward classes in the state services and is consistent with the demographic estimate based on the proportion worked out in relation to their population. The numerical quota of post is not a shifting boundary, but represents a figure with due application of mind. Therefore, the only way to assure equality of opportunity to the backward classes and the general category is to permit the roster to operate till the time the respective appointees, promotees occupy the post meant for them in the roster. Well, pausing for a moment here. Why this roster? Because 100% roster is prepared. Supposing the 7% of the post to be reserved for SC. 7% of the total post in the particular cadre. Out of that total post, 7%. 7%. Now, supposing here, these 320 new posts have come in. Those are new posts added to the already existing post. In the already existing, suppose there are 200 posts already there as junior engineers in that department. 7% of that 200 posts must have been filled up by now. Point-wise, 100% roster. That is the philosophy. Idea is this. And if you go beyond filling up post, then it will exceed 7%. It will be excessive. This cannot be done. That is why 100% roster point. Once those roster points fall vacant, those vacancies occur because of retirement, then you have to fill up those posts. Again, for those reserved category. You cannot bring in other category people there. That is the philosophy, that is the idea. That is why Supreme Court says that once it is completed, then it is over. Otherwise, it will be excess appointment. You cannot bring in. Now, that is why I am saying, supposing now subsequently another 300 new posts have been created. Then in that case, out of those new 320, 7% will be new post added to the particular category, reserved category. So here, that should be 22 posts for SC. Otherwise, it will fall short of the reserved category post. It will fall short of. Now, which those 22 posts will be filled up, you will have to specify in the roster point. Making a 100-point roster point, you will have to identify this post will go to, say, at point 3 SC, at point, supposing 25, it will go to SC, at point 60, it will go to SC, like this. This is how you have to identify and make this roster point. And then you must go for filling up. Therefore, said the operation of a roster at the running account must come to an end thereafter. It cannot continue for all time to come. The vacancies arising in the cadre after the initial posts are filled will pose no difficulty. As and when there is a vacancy, whether permanent or temporary in a particular post, the same has to be filled from amongst the category to which the post belongs in the roster. Therefore, whenever a particular roster point falls vacant, if it is for SC, ST, you just make a selection against that post and appoint a person of that category to that post. For example, the scheduled caste persons holding the post at roster point 1715 retire. Then these slots are to be filled from amongst the persons belonging to scheduled caste. Similarly, if the persons holding the post at points 8 to 14 or 23 to 29 retire, then these slots are to be filled from amongst the general category. By following this procedure, there shall neither be shortfall nor excess in percentage of reservation. This is how the Appellate Court has explained it. Now here, what I find, my lord, to my understanding, probably this reservation policy could not be understood by the authorities, selecting authorities, and by the departmental authorities. This is why they could not identify and make it specific in the advertisement. Mere understanding of the officers, mere understanding of the selecting authorities is not enough. They must be able to make the others understand what they are going to do, how they are going to do. They must make others to understand. There only their wiseness will come out. There only their knowledge will come out. That yes, they know it well. They have been able to make us understand it. That is why I say, I have not been able to understand it. 320 posts, 7%, 22 posts. Simple arithmetic. They say 12 posts. What is the magic behind? Why it has been reduced by 10? They have not explained it. Because we know that the officers who have been dealing with, department who have been dealing with this kind of filling up posts, appointing authorities, they are wise enough. They know it, but they do not want to disclose it. Why? Where is the transparency? Where is the transparency? How can they bring in PWD candidates against the SC reserve quota simply because they also belong to SC category. Obviously, it's a double reservation. Excess reservation, double reservation. They get the reservation as a SC candidate as well as they get the reservation as PWD candidate at the same time. That is to my understanding, going by their activity. And explanation that is coming forth supports what I have submitted before a lot. They say this is their categorical stand. This affidavit is submitted by Secretary APS. Secretary APS. So, obviously,
you apply for APSC.
It is not that APSC do not know. All they have been dealing with day in, day out such things. Only thing is, we have not been able to understand how they have proceeded. They could not make it so appear for the general people, general candidates, that this is how we should proceed. And when we look into the law and consider their action, we find lot of contradictions, lot of controversies, not conforming to the law. Therefore, my response submission is, my case was initially that at least one post must be left open for the SC simpliciter. You cannot bring in two PWD candidates. Now, I may submit legally even that PWD candidate, unless it can be shown that one PWD candidate will be brought into the SC category because here is a post which can be identified as a fit case for accommodation of that particular PWD. They even cannot bring in because they now here they have shown both two candidates with their reserve against reserve SC category. That is the position. And once one post, because I am only one here before this honorable court, if one person goes out, then I come. My marks are, as I have already said, what is that? Affidavit. My affidavit, additional affidavit, that is 14/11/22 at page, this appears at page 49.
Yes.
Page 51, I will place paragraph 4 straightway. Because here, kindly see, page 51, that on 29/8/22, during pending of this instant writ petition, the respondent number 3 published the aggregate marks of the selected candidates related to the recruitment to the post of junior engineer civil and under the Panchayat and Rural Development Department pursuant to the advertisement dated 24/6/2020 in compliance with the order dated 29/6/2022 passed in WPC number 4425 of 2022 and 441/2022. From the said list of the aggregate marks of the selected candidates, it has come to the knowledge of the deponent that out of 320 posts, 6 SC male candidates, 4 SC reserved for women, that is women candidates, and 2 SC PWD candidates has been selected. SC PWD candidate. Out of the 6 SC male candidates, the serial number 6 candidate, Orup Das, roll number so-and-so, has secured 127.75 marks. Since the deponent secured 127.25 marks, the deponent would have found a place in serial number 7 of the SC category post in the final select list if the respondent authority included one SCPWD post instead of two posts of SCPWD in this final select list. Hence, due to the illegality and without following the reservation policy of the state, including two SCPWD candidates in the final select list, the deponent petitioner has been deprived from his due entitlement and selection in the present recruitment process. Further, as stated above, if the petitioner is granted another 1 marks for quotation of wrong answers in the OMR sheet, he will secure 128.25 in the aggregate, and in that case, he would secure place in the merit list. Otherwise, also I claim that I am entitled to 1 more mark. They have not given it to me. But if I go by the marks they have already granted, that is 127.25, then I come in immediately after this Sumon Das. Okay? Yes. Sumon Das, who has secured 127.75 marks. Here, my marks lordship will find it was revealed because in the final select list showing the marks, aggregate marks, my name has not been shown. Because they have only shown those 2 persons, SCPWD and up to Sumanda. They had brought in 2 SC category persons, PWD category persons in the SC category. Therefore, they have not shown my marks. My marks, they admitted at page 53, lordship will find. This was my marks, they have informed me under RTI. Page 53, furnishing of information RTI. Now, it was Rajesh Kumar Das, the petitioner, addressed to me. Regarding the first, the narrative part, number 1, regarding the information sought against petitioner number 1, you are informed that the marks obtained by you in the written test are as follows. General Studies 48.50, Civil Engineering 58.75, additional mark 20. This is my mark. If we add up all, sum up, it comes to 127.25. Therefore, my claim is that 1 post I am entitled to occupy in the SC category. In whatever manner, you cannot have reservation of PWD against reserve SC category. I belong to reserve SC category, simply. At any rate, no 2 posts. Even if they can justify that at least 1 post we have identified there. And that's how the particular category of disability, 1 candidate selected against that particular category can be fit in there. Then of course matter would rest at a different pedestal. But otherwise. So my limited priority. There is a double reservation, excess reservation in the SC category, by bringing in 2 WD category, which cannot survive. And it must make way for me. Lordship will be pleased to direct them to consider and appoint me against 1 of those posts. And 1 post has been kept vacant. This Honorable Court passed an interim order initially by keeping 2 posts reserved. 3 posts. 3 posts, 2, yes.
SC simpliciter.
1 SC simpliciter,
1 SC person.
1 SC persons, and 2 disabilities.
And 1 SC women.
Women. 3 posts were kept back. Simpliciter, SC women, and 2.
It was modified.
Then it was modified. It was modified by order dated 5/1/2023. The Lordship will find the order sheet. Conditioning.
What?
Order sheet was, na?
5?
123.
5/1/2023.
Do not fill 1 post without properly. Only for the women part it was vacated.
1st January, my lord, 2023.
5-1.
5-1. It is passed in
Must
IA,
be-
I
must be
suppose.
the IA.
IA maybe, because they will file an application. Yes, IA 32221. 3221 of 2022. They filed an application for modification. That's how this matter was heard 2-3 occasions. And finally, this order was passed.
Uh-huh. 3221.
3221, 2022. In this case, I may be separately checked. It was filed by Onurupa Pathak. That women candidate came in. Is it there, Malad?
Yes.
Yes.
No, I can't get that order. Yes.
3221.
Mm.
Yes. 5-1-2023. Heard Mr. So-and-so. For the petitioner also heard Mr. So-and-so, counsel for the respondents in APSC, and Mr. So-and-so, learned counsel for the respondents in PNRD, and so-and-so, learned senior counsel assisted by so-and-so, learned counsel for respondent number 6. Heard the matter at some length. As the issue also involves in what manner the provision of section 33 and 34 of the Rights of Persons with Disabilities Act 2016 had been implemented. We have also requested the presence of Mr. D. Nath, learned senior government advocate, to assist the court in providing the information as to in what manner the state government has implemented the aforesaid provisions, and the records of such implementation may also be produced. That was a direction. We are clarifying that by the expression implementation as to in what manner in every establishment the appropriate government had identified the post which would be suitable for persons with disability, and further persons with which category of disability they are required to identify as per the mandate of the law. As our interim order dated 24/6/2022, a restraint order has also been passed to keep one post reserved for SC women to be not filled up. And as after hearing the matter at some length, it appears that no claim has been made by any of the parties for the post kept vacant, which is earmarked for SC women, and the respondent number 6 is already a selected women candidate in the SC reserve category, we modify the interim order to such extent that the earlier direction is to also not fill up one post reserved for women reservation of SC category shall now stand vacated, but while retaining the other provisions of the interim order. So, interim order in the main petition, Lordship will find dated 24/6/2022. Main petition, 24/6/2022. Yes. Lordship got it, my lord. This is a long order. Kindly come to 4th para. 4th para. Considering the prima facie case, my lord, considering the prima facie case till the next returnable date for one post each in SC category simpliciter, SC persons with disabilities, and SC women be not filled. So, there were 3 posts reserved, one SC category simpliciter, SC persons with disabilities, that is PWD, and SC women, not to fill up these 3 posts. That the women candidate came, and because we never says that women reservation is wrongly made, it is there. Therefore, court says that all right, that is vacated. But regarding this SC category, one SC category and one SC persons with disabilities, these 2 posts not to be filled up, that order is still operating. That was retained by the court while vacating the order in respect of the SC women category candidate by order dated 5/1/2023. So, there are now 2 posts lying reserved. two posts lying in reserve. And this is operating in merciful submission. At any rate, one post, since I come in on merit as justice simpliciter, should be directed to be filled up with this petition. Very my resolution. Subject to what my learned friends say, if necessary, a reply will come from my side.
Not if I'm appearing for the department. I will take only the vacancy part, Lordship, how these vacancies were calculated. The selection part will be taken care of by my friend. Also, to make the thing simple, Lordship will understand. One is vertical reservation, one is horizontal reservation. Vertical reservations are roster based, whereas horizontal reservations are vacancy based. Where from you will get that Lordship will straight away take the law, Lordship.
Which law?
This is the right of person with disabilities act 2016. Rights of person with disabilities act 2016. This is section 34.
You are appearing for?
I'm appearing for Disciplinary department.
This respondent?
Respondent number 1 and 2. Respondent number 1, 2, 1 and 2 now. Section 34, Lordship. Reservation.
Milord, my friends will be here, Milord. My friends should be. Obliged.
Section 34, Lordship.
Yes.
I'm not reading the whole section. First 2-3 lines. Now.
1 minute.
34.
Yes.
Reservation 34, Reservation 1. Every appropriate government shall appoint in every government establishment not less than 4% of the total number of vacancies. This is not cadre. This is vacancy. In the cadre strand of each group of posts meant to be filled with persons with benchmark disability.
1 minute. 1 minute. Let us read again.
Vacancies in it.
Total number of vacancies in the cadre strength.
Yeah. One cadre is there, vacancies are there in the cadre vacancies. Out of that vacancies.
No. It says vacancies in the cadre strength.
Yes. Total number of vacancies.
In the cadre strength.
In the cadre strength. In each group of posts meant to be filled up with persons with benchmark disability. Now, Lordship will come to the advertisement. Lordship, I have prepared in the IA, Lordship, IA 798/2023. IA 798/2023.
Yeah, what is here?
Lordship, this is the IA filed by one of the selected candidates, Lordship. Interim order was passed ex parte, Lordship. Subsequently, he filed this application under 226(3). Lordship, I have prepared in this case, in this IA, Lordship, that is why I am taking this. Page 32, Lordship will get the advertisement. It starts from page 31.
Page
31. It's advertisement dated 24 June 2020. I'm taking the next page, page 32.
1 minute. IA number 7.
798/2023.
Yeah. Page 32.
Page 32, Lordship will see the post junior engineer civil.
Yes.
Above that, Lordship B, name of the post junior engineer civil under Panchayat and Rural Development Department. Number of posts 344. Next, Lordship will see the breakup. Open category, total 144 posts, 43 posts reserved for women. Next, reserved for OBC, MOBC, 89, 27 reserved for women. Similarly, Lordship will get the last column, Lordship, posts reserved for PWD and type of disabilities. Number is 14. LV 4, deaf 4, and hearing impaired 4, locomotor disability 3, autism 3. Now, Lordship will notice here, first thing, these posts are not classified on the basis of religion or caste. These are classified on the basis of disability. Hearing impaired, autism, locomotor disability, etc. And Lordship will, second thing Lordship will notice, 4% of 344 is 13.76 Lordship. If it is rounded up, then it becomes 14. That is why 14 posts has been reserved for PWD. Total number of posts advertised 344. 4% of 344 is 13.76. If rounded up, it becomes 14. That is why 14 posts has been reserved for PWD. Now, if your Lordship calculates the post reserved for women, Lordship will see 103 number of posts has been reserved for women. Lordship will see the last column before the PWD column, Lordship. Last but one. 344 total number, 103 posts. Lordship, 30% of 344 is 103. That is vacancy base. 3% is to be calculated on the basis of the vacancy. 4% of PWD is to be calculated on the basis of the vacancy. That is why 4% of 344 is 14 and 3% of 344 is 103. And Lordship will notice both PWD and women are horizontal reservation. Where from Lordship will get that horizontal reservation? Lordship will come to the rule.
Which rule?
This is Rights of Persons with Disabilities Rules 2017. In that same book, Lordship will get that 2017 rule.
Yes. Yes.
Lordship will see Rule 11.
Yes.
I'm coming to Rule 11, Sub-Rule 3.
Yes.
3. While making advertisement to fill up vacancies, every government establishment shall indicate the number of vacancies reserved for each class of persons with benchmark disabilities in accordance with the provisions of Section 34 of the Act. Earlier section, just now your Lordship has read. 4, Lordship, important. The reservation for persons with disabilities in accordance with the provisions of Section 34 of the Act shall be horizontal. This is what the rule provides. Now, in other categories, Lordship comes to the other reservations in the advertisement, Lordship. Same page, page 32 of the IA, Lord.
Yes.
Lordship will see for MOBC, OBC and MOBC, 89 plus 27, this many posts were reserved. Same 27 to MOBC. Okay. Lordship, this 89 may not be OBC 10%, 27%. Of this reserved category, this notified number of vacancies not. Similarly, if your Lordship comes to SC,
13 posts were advertised. 13 may not be 7% of the 344. Because this is roster based. This is not horizontal lottery. This is not vacancy based. 13 posts of the SC category are vacant. These are roster based post lottery. That is why this is not 7% of 344.
Have you explained that in your affidavit?
Lordship, unfortunately, Lordship, PNR rule is there. Yes,
No.
APS.
Have you filed your affidavit explaining that?
No, Lordship, PNR has not filed.
Why?
But the distinctions are clear.
No, maybe. But at least you should come forward by way of an affidavit.
I'm just showing the figures, Lordship.
Oh.
This is clear, Lordship. Law also quite clear, Lordship.
Because you are the man, you are the department who has done the reservation, correct?
Lordship.
Who has calculated the reservation vacancies.
Lordship.
Correct. So you should explain it.
But otherwise, Lordship, these numbers are not underselling. This advertisement.
No,
was never
numbers.
selling.
SC reservation is under. They have questioned the reservation.
No, his question is if 3%, according to him, 3% of posts are reserved for PWD. If 3% of 12% selected.
No. What they say is 7% is reserved for SC.
SC, madam.
And if you calculate out of 320 posts.
That is his submission,
It
Lord.
comes to
And
two-
my
it
distinction,
comes to
my
22 posts.
Yeah. On that point only, I am trying to distinguish that roster-based points are, these are vertical reservations. Vacancies will be considered, numbers of vacancies will be considered only on the basis of the roster. But in other categories, other two categories, Lordship, it is vacancy based.
So that is the reason why I'm asking you,
Lordship.
why have you not filed an affidavit explaining that?
My lord,
So
my
that
lord,
they
already-
can counter it.
my
One
lord, there
minute,
is a-
1 minute. That's the whole thing.
Lordship, Lordship will allow me to complete my submissions. Lordship will consider whether an affidavit at this stage is required. Lordship will definitely consider that.
Yes, what do you want?
My lord, already there is a specific direction from this honorable court in the very inception of this case that to produce the records to specify and to, my lord, clarify regarding how they selected and how they, my lord, calculate all this reservation, my lord, whether they have followed the roster point or the vacancy or whether they follow the cadre strength. Already there is an order, my lord, 24/6/2022.
I've seen.
My lord. So I couldn't, they should have, my lord, to clarify before this court, my lord.
That's what.
That direction was issued to the government advocate, Lordship, and it was in respect of all the departments, not only in respect of PNRT.
But PNRT, since you are the concerned department,
Yes.
you file an affidavit, a short affidavit. Let us see what happens.
My only concern is that the Lordship, one person is selected person.
That is not
He
your
has been
concern.
kept,
That is not your
and
concern.
This is, no, this is because Lordship decision 226(3) application.
You are delaying the matter. You are keeping quiet. You are not coming forward with any
My
affidavit.
submission, we are also suffering because Lordship in another restriction 27 posts has been stayed.
That's why immediately file an affidavit, then we'll consider your matter. I'll give you 1 week time.
Lordship.
I report KK Mahanda, but KK Mahanda, then a senior counsel, assisted by MS and Begum, then a counsel for the petition. Stop. Mr. P. Nayak, then a standing counsel, PNRD department, is allowed a week's time to file affidavit.
Lordship, can you make it 2 weeks?
It's allowed 2 weeks time to file affidavit in opposition.
And Lordship will fix a date of.
List the matter again on, give a date after 2 weeks.
27 to 11.
27, 28, 11.
Aji kiman? 19, no? 26. On 9 Lordship. Subject to law. April, no. April, 2 weeks.
9.
10, 11 plus and 11 bonus and
Just before Bihu.
Before Bihu, Lordship, it will be motion matter.
That's what I'm thinking.
Yeah. And second, then not.
8th of April.
It's Monday. It will be motion days only.
2nd of April.
Okay.
11th, 4th of April. 4th of April.
My lord.
That will be 5th. Oh, yeah.
My lord, on 4, my lord, my senior will be out of station. My lord. Second, my lord.
Okay, 2nd April.
23rd এ ভালো না? After বিহু লক্ষে 23rd.
No, my lord. We'll
এইটা তুমি হলো ডিক্লেয়ার বন্ধনতে
Otherwise also he is in contractual engagement doctor. He is already working there. That is my only concern.
Whatever it is, you are expressing urgency in the matter and you are delaying the matter. It's up to you. You want to have it after Bihu, before Bihu? Anything.
Lordship, may kindly record it as a part third, Lordship.
No, I won't keep it parted. Let the affidavit come first. Anyway, I have got a nothings.
It will be. On 25th, Lordship, 23rd I will be out of session.
Is it?
Okay.
25th of April?
25th.
Based on 25th April.
Obliged.
My lord, interim may be continue, my lord. Interim is.
What interim order possibility to continue?
19, hearing.
Yeah, I know.
May it please your lordship.
You ready?
Your Lordship, if 2 days time may be given to me because there is a lots of document that I could not able to arrange it today.
2 days time.
Maybe come up on Friday.
Friday, your lordship, it will be a motion day. It will be
It's a
better to
motion.
file Thursday, your lordship. Thursday, your lordship.
Mr. T, you will learn counsel for petitioner.
21st, when it is okay. Then next Wednesday.
On request made by M. Shamal, understanding counsel for the Respondent Bank.
Yes, your lordship. Your lordship may come up on next Tuesday then, your lordship.
Which next Tuesday?
Yes.
Next Tuesday is a holiday.
Oh.
We're having Holi.
Oh, my only concern is my
Then Thursday.
Thursday, your lordship.
Then next Thursday.
No, next Thursday. No.
Then we'll have it on 2nd April.
2nd April, too far away also. May I pray on the next Thursday?
Unfortunately, there are so many holidays.
I understand.
So we'll have it on 2nd April.
2nd April. Deep your please.
20,
But we are for the respondent.
Ratings are complete?
Yes, my lord. My lord, we are asked to produce the record. We are ready with the records, my lord.
Where are the petitioner's counsel? Okay. None appears for the petitioner. Mr. D.B. Bora, London Standing Council Health Department, appears for the Health Department. And Mr. R.S. Rangan, London Standing Council, appears for KAC. List after 1 week?
Yes, my lord.
After 1 week.
Problem.
22,
My lord, the case of the petitioner is that, my lord, the petitioner was working as a
Case of the petitioner is what?
is the bank manager, my lord. And during pendency of the appeal, he died of accident. That is altogether different. Now, my lord, wife before your lordship, my lord, representing husband, my lord. At least some monetary benefits will be given, my lord. Initially, my lord, the petitioner was placed
You are
on
praying for the respondents?
Yes, your lordship.
respondent said, my lord, they will
Respondent bank.
Yes.
respondent bank said, my lord, they will not file affidavit, rather they will place the record.
You have the records?
Record is there.
Your lordship, my senior is on the way. I think the record.
Record is there, my lord. Last occasion also was there. Ase o thakibo lage.
If records are not there, there's no point in proceeding.
Okay, I think it's the record
Record must be there.
Who's your senior?
As the thought.
as the time.
Where is he?
He's on the way. Your Honor.
By this time, let me start, my lord.
Yes.
Lordship, I was placed under suspension by my lord annexure, page 36.
Page
36. Well, I was a branch. That is, my lord, only suspension, my lord. Thereafter, my lord, what happened?
1 minute. You are Mukut Chandra,
My lord, Mukut,
your husband's.
my lord,
husband's name.
my lord.
Suspension order. This is the order?
My lord, this is the order. 18/5/2019.
Yes.
Thereafter, my lord, I have been issued and show cause that your lordship will see at page 37. Operative part is page 42. my lord. To save time, my lord, I am skipping, my lord. Thereafter, my lord, lordship kindly have,
Place your case properly.
my lord. There, my lord, I have been issued a show cause notice, my lord.
Datta, have you got the records?
Yes. But
So-
only thing what I'm thinking, it may take some time, my lord. At least I will take more than 1 hour. Whether you can finish it.
Can you finish?
My lord, I'll finish it, my lord. I'll not take much time, my lord.
All right, in that case, it's okay.
Let me finish.
I don't want to keep it parted.
My lord, why, my lord? I'm insisting, my lord, because I'm the widow, my lord. I have now money to eat, my lord.
That's not the question, my lord.
My lord,
Question is,
that's
what
why
is the
I'm not
chart?
asking for
How
any
it has been
question.
established?
I am only, my lord, insisting, my lord. I am a widow, my lord. I have no means of survival, my lord. That's why I'm facing acute financial hardship. If I get something, then only I can, my lord. That's why I'm insisting before your lordship last occasion also. Anyway, my lord, lordship kindly have a look at page 37, my lord.
Yes, Shokos.
I have been issued a shockers letter, my lord. Just operative part I'm reading, my lord.
Oh.
It is alleged that during the tenure of the service branch manager Gorukhuti branch from 25/16 to 7/5/19, you have sanctioned and disbursed 217 numbers of so and so within a period of 16 months from 17/7/16 to 18/28/11/17, altogether an amount of 4,15,20,000. That is 4 crore 15 lakhs 20,000 was sanctioned against 217 numbers of SHG, that is self-help group, my lord, the loanee. Self-help group where sanctioning the lease loans, you had committed gross and serious irregularity, and they have given a chart, my lord. An operative part of the conclusion of it starts at page 41, my lord, last line, para 9, my lord.
Last page.
Page 41, para 9, my lord, last bottom.
Yeah.
Valid, my lord. The transaction and recovery status of the loan account are very poor and negligible. There is an outstanding balance amount of 4 crore 19 lakhs. Now it has been increased, my lord. Earlier occasion, it was been asked for 4 crore 15 lakhs. 16 lakhs 52,465 self-help group account so and so against the sanction outstanding amount of 4 crore 15 lakhs. All the loans are going to early monthly category, and above facts reveals the reckless you have received and discretionary power causing huge financial loss to the bank, my lord. Then lordship turn to page 42. In view of the above, you are advised to explain the conduct and aforesaid serious irregularities committed by you during the tenure of the service branch manager of Gorukhuti branch. Please show that the cause and disciplinary proceeding will not be initiated against you for committed of these irregularities. Your reply should reach to underside within the 15 days. Then lordship will see page 43. I have given my show cause reply denying all the allegations that is dated, my lord, 3719. I have I have denied everything, my lord. Operative part, my lord, will be at page 44, para 3, my lord. May I read, my lord? Show cause reply, my lord, para 3. The statement made in of your letter categorically deny and same begs to state you the KSC documents obtained from the office bearer of the groups were neither fake nor tampered document. I further beg to state that as per the norms of the bank KYC document, KYC know your customer, my lord. The documents all the members of president and secretary of all the self-help group were obtained. Moreover, it is the duty of the credit officer. Lordship, kindly note down that point, my lord. It is the duty of the credit officer to receive the loan application as well as check and verify the loan applications along with the relevant documents as required as per the procedure of the bank. Accordingly, all the documents furnished with the said loan application were checked and verified by the credit officer of the Gorukhati branch. Thereafter, credit officer put his signature in his column of the loan application and submitted the application before me. My lord. Then lordship will see para 5. 4 is not that much required, my lord. Para 5, I have stated, my lord, in the second paragraph, my lord. Further, I beg to, I am totally not aware of the withdrawal were treated as a transfer voucher and large amount of the different saving bank self-help group transferred by to saving account of few individual self-help group withdrawal slip were collected and alleged in your letter because it is not under my duty to check and supervise then office bearer of the self-help group withdraw or transfer money from its saving account. It is pertinent to mention here that as per the bank's norm, the cash of non-ability of the check in the branch withdrawal slip can be used and treated as a transfer voucher of the money. Meaning thereby, my lord, during that point of time, if the check is not there, my lord, suppose I do not have the check at the particular bank, my lord, then my lord, withdrawal slip will be used, my lord, for withdrawal as well as for deposition of other account. That will only has done it, my lord. Then lordship will see, I'm skipping, my lord. Thereafter, my lord, I have already replied to their show cause, my lord, and they have intimated me by page 51. Though it is confidential, it was supplied to me, my lord. I have received your letter number so and so. In response to your letter under reference in connection, we have to inform you that the reply furnished to you is not found to the satisfactory and convincing. Hence, reserve right to proceed against you as a deemed fit disciplinary authority. Thereafter, my lord, a departmental inquiry was that your lordship will see annexure 5, page 52. 52, my lord. There have been given article of charges. Article of charges, my lord. Same thing repeated, my lord. And conclusion of that article of charges, my lord, what they have made me charge, my lord, it is there in the bottom at page 60. Lordship has come across of page 60.
Yes.
Bottom, my lord, having gone so, you are grossly violated regulation 18 and 20 of the Assam Gramin Vikas Bank office, so and so amended, which attracts the penalties under 31B, 31(1)B of the said service regulation. That I'm coming, my lord, through the regulation 18 and 20. What is about? I'll supply the book, my lord. Regulation, I got one copy. I'll supply it, my lord. Thereafter, my lord, I have been asked to submit the written argument by page 61, annexure 6. I have given, my lord, written statement against the article of charges. Mostly, my lord, I have submitted, my lord, and I have denied, my lord, and I have made my submission, and I have said, my lord, there is no irregularity committed by me, nor I have violated regulation 20 and 2069 that your lordship will see of my reply at page 69. 69, my lord, last part of my show cause reply, my lord. bank prior to the alleged incident, it is no point of time any such allegation ever arose against me. Sir, in replying to your letter, I am respectfully beg to submit that neither any such irregularities were committed by me, nor I have violated Regulation 10 and 18 and 20 of the regulation, my lord, of Assam Gramin Vikas Bank Service so regulation during my tenure of the service career as charged against me. You by your letter dated says, I humbly request you not to initiate inquiry against me. Regulation 13.1B of Assam Gramin Vikas Bank. Thereafter, my lord, another letter was issued at page 70 for the appointment of the page 70 appointment of the inquiry officer.
Where is that?
That inquiry lordship will see page 72. I have been appointed at one person have been appointed as a inquiry officer at page 70.
70.
70, man. In consideration that the reply of Mukut Sharma, branch manager under suspension, Assam Gramin Vikas Bank, received the reply to the bank's letter dated so and so to 12/19. That is the article of charges. Under the regulation 19 of the Gramin Vikas Bank so and so regulation found not satisfactory, and it is decided to hold departmental inquiry to the to the charges level against Mukut Chandra Sharma, branch manager under suspension so and so. Whereas the undersigned considers the appointment of the inquiry officer to inquire into the charges level against the sheet mentioned herein, so also presiding officer to present the bank case at an inquiry officer powers conferred upon him under regulation 41 and 39 of the Assam Gramin Vikas Bank so and so. Sri Rajendra Nath Gogoi have been appointed, who is the senior manager, and he has found an inquiry officer was done, my lord. And he has submitted his reply, my lord, findings at page 84 is the operative part of the inquiry report, my lord.
Inquiry report.
Yes, my lord.
Where's the inquiry report?
Inquiry report starts from page 72, my lord, and operative part is page 84. What is the findings of the inquiry officer, my lord? Page 84, my lord, last 4 lines, my lord.
1 minute. Are you challenging this inquiry report?
Yes, entire thing, my lord, I'm challenging. I'm the coming, my lord. Chronologically, I'm going, my lord. During the inquiry, CSO he was not able to defend himself against any of the charges level against him, nor he was able to produce any documentary evidence in his support. Thus, all the charges level against him by letter dated has been established. This is the inquiry report. Thereafter, my lord, I have submitted my written argument, my lord. Lordship, kindly have a look at page 87. Para 2, middle portion. Or entire thing may I read, my lord. Para 2. That charge number 1B of the brief argument submitted by the manager presenting, I argue that and deny the group photo was attached the loan documents for different 4 groups members. I further deny that any fictitious loan was ever created by me. It is pertinent to mention here that the group photograph attached with the loan documents ME so-and-so number so-and-so were never exhibited in the departmental proceeding to prove those group photographs were saved. Thereafter, my lord, I'm just highlighting, my lord. Thereafter, page 68, my lord, regarding the authenticacy of the PAN card, the middle portion, my lord.
Page?
Page 88. Middle portion, my lord. Lordship, kindly read from proof PAN, that PAN.
Oh. Hmm?
Lordship can read from, my lord, extreme right hand side, a person who is the not office bearer of income tax department. Middle portion, my lord. A person who is not the office bearer of the income tax department can't prove the PAN card is authenticated or fake or tampered one. Similarly, a person who is not the office bearer of the office of the election commission of India can't prove the voter ID card is authenticated or fake or tamper one. As such, the evidence of MW1 stating that the KYC documents fake tampered is not at all acceptable in the eye of law. Documents information collected considered from the official website of the department is electronic document. That I have denied, my lord. Thereafter, my lord, page 89, para 4. That the charge number 3 made in the argument submitted by the manager and presenting, I argue that I have already stated the detail where written statement self-help group mentioned in the list were not formed during my tenure. Lordship, kindly look down that point. The self-help group was not my tenure in the Gorukuti. It is not proof the departmental proceeding that during my tenure at Gorukuti branch, the said self-help group mentioned in the list were formed. Never the evidence of MW nor any documentary evidence states that the aforesaid self-help groups were formed during my tenure at Gorukuti branch. Gorukuti. As such, I am not liable for any, for some person has come the members of the group or during that. Thereafter, my lord, that is very important, my lord, page 90. Further, I deny, lordship, kindly read the para 5. I argue that para 5 that the charge number 4 made in the brief argument submitted by the manager president. I argue that it is not the duty of the scrutiny and after sanctioning the loan of to self, if the said self letter bent the money, it is not the concern the self down the checks were issued and transferred to saving account some other individual self-help group as such. It is not proof that I have violated the bank snub. I further beg to state that I am totally not aware of withdrawal slip were treated as a transfer voucher. A huge amount from different saving bank accounts were transferred to saving bank account of few individuals saving self-help groups, and withdrawal slips were collected as an alleged because it is not under my duty to check and supervise if any office bearer of the self-help group withdraws transfers money from its saving account. Thereafter, my lord, I did not get the document, my lord. Then I have written to them, my lord, that
What
your
document?
some documents, my lord, in the departmental inquiry, I have not been provided, my lord. That your lordship will see page 99. Page 99, type copy is there, my lord. Reference order dated 28/20 passed by the departmental inquiry proceeding against Mukul Sharma by letter number sensor. Prior for supply of the copies of the document being serial number 4567 in ME3, material exhibit number 3, and statement of witness if any. Sir, with due respect, I beg to state that I am the charge sheeted officer in the departmental inquiry proceeding by letter number so-and-so. On that, sir, on so-and-so, I was present in the departmental inquiry. Honorable inquiry officer in the above mentioned department inquiry was pleased to pass following orders. The defense side is allowed 15 days time to verify the documents listed above M3 in original place of occurrence. PO is directed to arrange the verification original listed documents within the specified period and so and submit the same to the inquiry officer. The defense side is advised 15 days to discover the defense documents if necessary, which are required for the purpose of the defense. Then lordship will see page 100, the type copy of my lord, continuation of that, my lord. That's our, we are pleased to fix a departmental inquiry on 18/3/20. That's our most respectfully, I beg to state that I have already received the list of document, list of witness, but the copies of the documents, more particularly serial number 4, 5, 6, 7, ME3 and statement of witnesses have not been served upon me till date. So, my lord, he made a prayer. As such, I humbly pray your sir to allow me to defend myself the aforesaid departmental inquiry and pray to supply me the copies of the documents, specifically 4, 5, 6, 7 in ME statement of witness, if any, and to prepare for my hearing held on 18/3/20. Thereafter, it did not work. Again, my lord, I have written them letter at page 101. 101, my lord. I have asked, my lord, prayer for the certified copies of the document, my lord, 1 to 6, my lord. There I prayed, my lord. Once again, I humbly request you to provide and furnish me the certified copies of all the papers relating to the document listed as per the above mentioned letters early, so and so. Further, I request you to give me at least 15 days time and to hand over all the papers prayed to verify the scrutiny of my proper defense in so and so. I am surprised, despite the repeated requests to record the inquiry proceeding held on so and so. No, my correspondent letter 15/5 earlier letter memo was not recorded. Sir, my presence letter requesting you hand over the certified copies of whole documents. Thereafter, it did not work, did not supply, my lord. Then, my lord, I was compelled by Annexure 3, my lord. I have made an written argument, my lord. Written argument, and I have categorically stated at page 105 para 3, my lord. That is the part of the inquiry, my lord. I approached to them authority to supply the copies, that did not. That's the finding recording charge number so and so, para 3, my lord, page 105. Submitted by the inquiries. I beg to submit before you, sir, that I deny the same group photos was attached with the loan documents for different self-help groups for different group members. I further deny any fictitious loan was ever created by me. It is pertinent to mention here that the group photo attached with the loan documents, Amy so and so, were never exhibited in the departmental proceeding to prove those photographs are same. It has not been provided, my lord. Thereafter, my lord, I have submitted my written argument. I have categorically stated, my lord, supply the particular documents to defend my case. That did not act upon. Ultimately, my lord, page 121 is the first impugn order, my lord, by which I have been removed from service. Page 121. 121, my lord. May I read, my lord? Yes. A departmental inquiry was held into the charges against the bank so and so, charge number so and so, observing the principle of natural justice. Reasonable opportunity was given to you in the said inquiry, taking proper facts of the so and so order participated in the inquiry. I have carefully perused and day-to-day proceeding evidence adduced both sides finding of the inquiry officer substitution loans. I concur the finding of the inquiry officer and evidence so and so recorded so and so. After considering all the facts and circumstances and gravity of the offense, I impose upon you the major penalty in Rule 39(1). That not specified, but Rule 39(1)(b) is there, my lord. I got the book. Thereafter, my lord, I preferred an appeal, my lord, at page 122 on 19/10/20, my lord. Within a period of 6 months, I have, within the statutory period of 45 days, my lord, I have prepared my appeal. That appeal I have prepared. Thereafter, my lord, my luck did not favor me, my lord. Ultimately, I died, my lord, at page 135.
Appeal is still pending.
Appeal was pending. Thereafter, I'm coming, my lord, chronologically. Thereafter, my lord, page.
When did you die? Your husband died?
My husband died 8/7/21. I have annexed the death certificate at page 135. 135, my lord, is my death certificate of my husband. Sorry, ma'am.
Oh.
The date of that Mittur Tariq 8/7/21. Thereafter, my lord, it did not work upon. Then I was compelled to issue a legal notice through my learned brother, my lord. Then, my lord, in reply to that, my lord, they have issued another impugn order at page 138. It is not a final order, my lord, that I am coming. With regard, last page, my lord. Lordship has come across.
Yes.
This has a reference to appeal petition above. In this regard, so and so, I am to inform you the above mentioned appeal number so and so Mukut Sharma submitted before the chairman, the appellate authority of the bank reviewing the punishment order issued by the general and disciplinary authority, bank's order accordingly after careful pursuing of the records, inquiry officer adduced, considering the facts, and so chairman so and so, the appeal so and so Mukut Sharma is upholding the general manager discipline officer. This is only communication. It is not a final order. Thereafter, my lord, what happened? During pendency of the writ petition, my learned senior brought.
Also impugned.
This is also impugned. Because it is a communication, my lord, it has been issued by head of the department, not by the authority, appellate authority. No order was communicated, it's subject to a legal notice. After notice, they only served. Lordship, kindly have a look, my lord. This is for favor of your information. Yours faithfully, head of the department and vigilance.
Where?
At page 138, last bottom, my lord, signatory. Yours faithfully, head and departmental vigilance. He is saying, my lord, head of the department is saying the appellate authority has affirmed the order, but there is no such order. During pendency of the writ petition, my lord, my learned senior brother has submitted a document that is also communication, which I have filed additional affidavit. Lordship, kindly have a look. My additional affidavit. Lordship, kindly turn to page 143. One 143, my lord, only one annexure. Annexure 19, my lord. These are the facts, my lord. Lordship, kindly turn to the page 144 of the last page of the additional affidavit. Further, the vigilance committee head office in the meeting held on so-and-so cleared so-and-so and was fraud and concerned Gorakhpuri branch, the loan sanction so-and-so differential during the tenure. He's highlighting all the facts, my lord. After completion of the departmental inquiry proceeding, all the charges against the Sharma has been proved beyond doubt. Accordingly, the punishment was imposed upon him, general manager dismissal, as dismissal. Now, my lord, he has come as a dismissal, my lord, word never been used earlier occasion. Because 39 says, my lord, different types of punishment that I'll supply to your lordship. As dismissal within immediate effect, so and so. Sharma has submitted the appeal before the punishment placed before the chairman appellate authority for kind perusal and necessary advice. Meaning thereby, my lord, my appeal has not been taken into consideration and no order has been passed on appeal by the appellate authority. Because head of the department, general manager, appellate authority ought to have passed some order in either against me or my favor with reasoning, but nothing has been done. And simply, my lord, he has produced, my lord, the record will reveal, my lord, let them show a single copy of the appellate orders. That's why, my lord, at the first instance, Honorable Court directed to produce the original record, particularly to show that, my lord, whether any appellate order is there or not. There is no such appellate order. Even though, my lord, the communication after issuance of the legal notice that I put into challenge, my lord, with a prayer to set aside that and to give me my benefit. Now, my lord, my learned friend will show, my lord, whether appellate authority has passed any order on me, on my appeal. And apart from that, my lord, the law says, my lord, lordship, kindly have a look, my lord. I have given tag mark 18. There is their own law, my lord, governed by my service of the husband of the petitioner, my lord. I have flag mark 2 yellow. 18 and 20, they have article of charges said 18 and 20. But while giving punishment, my lord, major punishment has been given. That too, my lord, without following the minimum mandates of the law. So entire proceeding initiated against me, my lord, are bad in law, liable to be, my lord, set aside.
Yes, regulations.
Yes, my lord. I have given, my lord, flag mark. Lordship can retain it. I'll take some other day, my lord. Lordship will see, my lord, 18 and 20, for which, my lord, article of charges was issued to me. And penalty portion was also there, my lord, because they have issued me a penalty 19(1)(b). 19(1)(b), my lord, there are 4 or 5 sets of another yellow flag or orange flag, lordship will see.
Yes, 20.
Lordship will see yellow mark. I have highlighted with the yellow mark. 20 and 18 and 20. and 20, that your lordship will see article of charges at page 60. My lord will see at page 60. Page 60, my lord, having done so, you are grossly violated regulation 1820 of Assam Gramin Vikas Bank Office Employee Service Amendment Rules 18, which attracts the penalties under 139(1)(b) of the said service regulation. Page 60, and that is the law. And penalty, it is there, my lord, 39(1)(b). 1B, there is a different sets of another orange color matter. Yes, Lord. 39 1B matter. Only I may be pardoned because I might have used red ink well in my chamber matter.
39.
1B. That is not specified in the impugn order. Now the core issue before your lordship is that, my lord, in the instant writ petition is that, my lord, during inquiry proceeding, I have asked some particular documents, even written communication also I made. They received it, acknowledged they did not supply. Rather, they proceeded, my lord, against me without supplying documents that I have annexed, my lord, page 99 and 100. Probably from the record, lordship will see only one witnesses they have examined. They have relied. Then your lordship will see from the record, my lord, whether there is any appellate orders with the reasons that for these reasons I am not confirmed, so your job is no more there. They have issued only, my lord, 19(1)B as a dismissal impugn order, my lord, which I have impugned in my writ petition, my lord. That your lordship will see at, my lord, what impugn? At 121, my lord. 121, lordship can have a look again, my lord, what they says about. What they says about. Last paragraph, my lord. After consideration of the circumstance of the case, gravity of the proved misconduct and past records impose you under the noted major penalty in terms of regulation 13(1)B of the Grameen Vikas Bank. That is there, my lord. They did not mention dismiss or there is other sorts of penalty, lordship has seen, my lord. There are 4-5 sets of penalty in 31(B). But appellate authority, my lord, the very person which I have filed my additional affidavit as well as the impugn as page 138, very person, head of the department, my lord, he said, my lord, that findings of the impugn order has been affirmed, but there is no such order. As well as, my lord, I was compelled to file additional affidavit bringing into knowledge of the court, my lord, there is no such order. Only bottom of the page 143, my lord. And that is has been supplied upon me only during pendency of the writ petition by the counsel of the bank, which order will reflect this. So in view of that, my lord, the entire proceeding suffers from malice as well as, my lord, all the impugn order are liable to be set aside, my lord. And I have been given all the service benefit of the petitioner from the date of suspension to his reinstatement. Reinstatement question does not arise, he died. So, my lord, till his retirement, I am entitled all the benefit, including the retirement whatsoever benefit, that monetary benefit has.
No, you have not retired, you have died.
I died.
Your husband died. So
Husband died.
it will be from the date of suspension up to, if you are successful,
Yes, my lord.
up to the date of death.
Retirement. Retirement.
Death.
After the retirement or that, my lord. After that. Thereafter, my lord, retirement question will come. My benefits will come if I succeed in the case. Now, my lord, lordship will see only vital document, my lord. All the documents, page 99.
So your ground is
Non-supply of the documents. Inquiry I have written, I have asked repeatedly. I have made an argument also that this document you have not given. Page 99 and 101 and 102. I have written, they have duly acknowledged. Number one. Number two, my lord, they have not followed the established procedure because law says something. There is a penalty provision is there. Which penalty I have been imposed, that is silent. They said you have been removed. Under what, my lord, there is a categorical, there, my lord, some 5, 6 are there. They have not mentioned. Hardly, my lord, I have made an appeal, preferred an appeal against the impugn order, page 121, that they have did not acted upon. did not act upon, for which I issued a legal notice. Upon receiving the legal notice, somehow they have consoled us, giving the last page, my lord, that the appellate authority did not consider. When the matter was in session and argument, my lord, during pendency of the writ petition, supplied me a copy. That also reveals, my lord, something is pending before the chairman. Whether chairman has acted or not acted upon, record will. Over and above, my lord, is a prima facie case, my lord. They have failed miserably to establish the guilt of me, my lord, without supplying document. It is vitiated, my lord. Then appellate authority also did not pass any order as on date, my lord, because on the last occasion, he has supplied a copy. If there is no appellate authority, my lord, the person, my lord, bank cannot be allowed to run on their own wisdom. In view of that, my lord, all the departmental proceeding, all the MP note are annexed in the writ petition that has to go with my consequential benefit. That's all. Now, my lord, before starting, my lord, lordship, can you have a look whether any inquiry office, whether any appellate authority order is there or not?
Any order pass?
Yes, yes. My lord, your lordship, kindly see the. My learned friend has referred his additional affidavit as page 144.
No, that is.
That is the bottom, my lord, I read out.
Not the
Now-
final order.
Page 143.
Huh.
In the left-hand side, your lordship, kindly see. Decision of DA is logical. Appeal not to be considered. This by the chairman.
After that, what happened?
These are the findings given. Is a brief was made by
Where is the
officer.
document?
Now he has given his finding that decision of DA is logical. Appeal not to be considered. Now, in short, that's the reply. Now, in regard to my lord, my learned friend argue very vehemently that no document was supplied, whether it is correct. Now, that is the reply what he has given. This is a pleading. Is there any evidence? I'll take your lordships to the my lord.
Can you complete in 20 minutes?
No, not at all, my lord. I will take to the charge sheet. Your lordship will find the dismal condition of the charges. How?
Okay, then I won't hear you today.
My lord, I think initially I said that I will take more than an hour.
You're correct.
So, my lord,
That I'll give you sufficient. Only thing is, so far as the appeal is concerned, you are saying that is the order.
this is the order. And regarding document, my lord, the disciplinary proceeding original records are here. I will show he has accepted saying that, my lord, the exact wording is like this. My lord, he has said, inquiry officer asked the defense side if they verified the documents as listed by the PO. The defense side replied that they verified the documents and submitted certificate to that effect. The defense side handed over the certificate to the inquiry officer, and the inquiry officer marked that as DE1. So, my lord, how they say repeatedly he was arguing, the document was not supplied. And another thing, your lordship will find the entire disciplinary proceeding. Notice on a single question, on the single charges, he has cross-examined the management witness.
Okay.
Neither, my lord.
Given chance.
He didn't. Oh, why you say that? Record is with me. I will show you.
Then the other one, I'm just skipping.
My
The third one, that the order of the disciplinary authority does not specify the penalty.
No, no, it's not correct, my lord. Your lordship, he has confused to that. What is about regulation 18 and 15? Your lordship can.
No. Regulation
39.
39 1B.
Yes,
39 1.
39 1B is dismissal. My lord, that is very amply clear.
According to here, 39 1B. 39.
Yes.
What is it? 39 1B.
My lord, your lordship, kindly come to 39 1B, then Roman 5.
It's not specified.
Nonetheless, it is a dismissal order. It comes from there. It's not that the source of power is not there. The last one, my lord. In the top 39 penalties, then your lordship will find 1 officers, A minor penalties, then B major penalties. Then your lordship will find Roman 1, 2, 3, 4, 5. 5 is the dismissal.
But here just actually there's no specification.
No specification.
No,
Possibly this is an old one. Your lordship may see that this 2010 service regulation, 2013.
My lord, from the page 121 be seen, man. Exact word lordship will get. And they choose not to file affidavit.
No, from the record, I will show. Down below, my lord, last one.
39-1 is officers.
39-1 is officers, then your lordship.
B is major penalties.
B is the major penalties. The last one is dismissal.
5.
5.
But then here there's no mention of 5.
I think this is the old one possibly.
No, according to your book also.
Is there, my lord? 5 is dismissal.
No, 5 is dismissal, but in this order.
Order,
Page
my lord,
121.
they have referred 39. 39 includes all these. My lord, either these or that in accordance
So,
with the.
so no, it may be reduction to a lower grade also.
Yes, there, why not
But
other?
then when the dismissal order is passed under facts and circumstances, my lord, when the matter, your lordship will hear the matter, what are the charges, how it has been established. But all the charges have been proved.
Okay.
And he did not challenge anything, never cross-examine. Even, my lord, your lordship will find he did not abuse any
Document
evidence.
has not been given, inquiry officer himself saying at page 84, my lord.
Everything will speak out from the record, then you'll keep mum yourself.
Jai Barwell and the counsel for the petition.
My lord, 1 second, I'll take my lord.
Also heard Mr. S. Datta, senior counsel, assisted by Mr. M.S.
Yes, Mr. Hari.
S. Mushari, Leonard, counsel for the respondents. We'll have to keep it part heard then.
Part of your lordship can conclude, my lord, from the record, your lordship is there,
Okay,
because
how-
they have
how-
not, because they did not choose to file affidavit, my lord.
How can I
My lord,
conclude?
since, my lord.
Acha, part heard, my lord.
Friend.
Okay, my lord, part heard, my
That
lord.
should be again.
Lordship.
So, my lord, he is saying that I did not file a affidavit. Is it necessary, my lord? When the record is with me.
Yes,
I-
all
it's
the
not
cases,
required.
my lord, the now new law has to come, my lord.
Heard in part.
Lordship.
Please for further hearing when shall we have it?
Day after tomorrow, my lord, Thursday.
It will
No,
be
this week, my lord, very loaded one.
It has to come in the after the holy after the Good Friday.
My lord, that will be back in.
After your lordship, man.
You were convenient day.
Any day, my lord, sometimes Good Friday it is on 29th holiday, na? Good Friday. 4th April.
Fourth, my lord, fourth, I'm preoccupied. There is a division.
Or lordship can fix it, my lord. 9th of my lord, Bihu holiday will be overloaded. Or lordship can fix is the 2nd. If it is pre-overload, my lord, he can make a mention. I'll give consent, my lord. In advance, I have given consent. That you make a mention and fix another.
So he's going to make a mention.
No, no.
Yes, let him make, my lord.
No, I don't want to rely on all that thing, my lord. The lordship can fix it 9th, my lord.
9th, my lord, Bihu loads, my lord, last day of the court.
Maybe a motion week.
Motion week, my lord. It is very difficult. The lordship fix the matter on 2nd, my.
2nd, my lord, not possible. There
2nd or my lord, 4th.
After Bihu.
Is better after Bihu, my lord. Let us be comfortable in arguing the case.
23rd.
Not 23rd. I told you, my lord.
23rd April.
Lordship. On that day, my lord, lordship give me chance also some documents from the record. My lord.
In item number 20, Lordship, we have shown as non-appearance, Lordship. We are waiting since morning, Lordship, but we had to go to another court, Lordship.
Mr. V.D. Goswami.
He went to the another court, Lordship. That is why, Lordship. He's waiting till 3 p.m.
What
Lordship.
order did I pass?
And non-appearance, Lordship, that may be corrected, Lordship. And that may be fixed, Lordship.
Item 20. Oh, Mona Lisa took it.
I heard that, Lordship, we have shown as non-appearance.
Yeah, your good name?
JM Google, Lordship. My name is here, Lordship.
Heard Mr. J.M. Gogol and counsel for the petitioner. J. Gogol.
J Google, but JM Google, Lordship.
J.M. Gogol. Then you just said tell Mona Lisa to cancel the non-appearance. Put item 20. And the rest will be like as it is.
I pay for a debt, maybe.
No,
if
no, I've
convenient,
already
Lordship.
Before your lordship rises, note item number 23, my lord. Lord, I am for the responding in the matter, my lord. Petitioners are also present, my lord. If your lordship kindly fix a date because I am traveling from Kolkata, my lord.
Okay, heard Mr. P.K. Munir.
Lord, I am Mr. Arnav Chakraborty.
P.K. Munir, legal counsel for the petition. Also heard Mr.
A. Chakraborty.
A. Chakravarti, learned counsel for the respondent.
No, 2, 3, and 4.
2, 3, and you are the CGC.
No, I am for the engineering project India Limited. I am the principal respondent. my lord.
Okay, 2, 3, and MS. Huh? Ms. K. Fukan on behalf of
And speak on behalf of Ms. State Corporation.
P. Tamuli, learned counsel on behalf of Ms. K. Fukan. CGC. For respondent 1. When do you want?
Yes, for his permit.
It has to come after Bihu only.
Yes, your lordship.
All the other weeks are loaded.
In that event, my lord, if your lordship gives some precedence of the matter and.
No,
it can
no,
be posted.
you,
22, my lord.
since if you're coming from outside, you can take your date.
The 22nd of April, my lord.
That's not a hearing week, that's not a hearing day.
Then 25th, my lord. 24th or 25th, or 23rd also, my lord.
25th.
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 My lord, may it appear in the, my lord, a little bit higher in the list, my lord.
That this is a
Give some.
2023 matter, it has to come serial wise. Pull out the last case.
My lord. I didn't put it.
24.
But in this case, a date may be fixed, my lord.
Yeah, Mr.
I'm S.C. Das from the petitioner, my lord.
Heard S.C. Das, then the counsel for the petitioner also heard Mr. U.K. Goswami.
My lord,
You are hearing for?
for the respondent.
Also heard Mr. U.K. Goswami.
No.
Then the CGC for the respondent. When do you want?
My lord, it is preferably 28 this month or my lord, 2nd of April.
After Bihu, after Bihu.
After we do that, my lord, it is 23rd. Some urgency is there.
It's on 23rd.
23rd.